Yes, Senator, please bring
You
the
guys want to
panel
sit up here? I have two firefighters with me.
So welcome to the Senate Finance Committee. Today is Tuesday, March 10th. We're going to hear a lot of bills, 14 bills today. We do have 72 witnesses, so I ask that when your 2 minutes are up, please finish your sentence so that we're not here all night. I really appreciate that. And we're going to start with number 1, Senator Jennings, county's no-cost preventative cancer screenings for volunteers. This is a familiar bill. Last year we did it for paid firefighters, didn't we?
We did.
Yeah. Thank you, Senator Jennings. You can begin.
Thank you, Madam Chair, distinguished members of the committee. For the record, Senator J.B. Jennings for Senate Bill 579. This bill extends the Jimmy Malone Act of 2025 that was for career firefighters to volunteers that have access to no-cost prevention cancer screenings. As we know, firefighters face a lot of hazards out there doing their job. There is no difference between a career or a volunteer firefighter with what they face out in doing their job. They use the same equipment, the same breathing apparatus, the same turnout gear. Nothing is different. However, what is different is the bill that passed last year was strictly for the career. This one focuses now on the volunteers. If you look at our state, 70% of our state geographically is covered by volunteer firefighters. And that's why, this is trying to make up for those that are not covered. When you look at cancer, it is a leading cause of death among firefighters. Studies have shown that firefighters have a 9% higher risk of being diagnosed with cancer and 14% higher risk of dying from cancer compared to the general population. This legislation requires counties with the volunteer fire companies to provide no-cost preventative cancer screenings to volunteer firefighters in accordance with established medical guidelines. Counties may meet this requirement by providing an annual medical exam that includes cancer screening or by utilizing the state's firefighter cancer screening technologies program. What I would like to note is this is, to qualify for this in the bill, members must meet their LOSAP requirements. And LOSAP is the length of service LOSAP length of service award program. Thank you. That's ensuring that they're meeting all the requirements to show that they are active within their department. This bill it's personal for many of us. Those of us that served with Jimmy Malone, unfortunately, we lost him 2 years ago to cancer. He was both a career and a volunteer. Very proud of his time with the Arbutus Volunteer Fire Company before moving up to Harford County with the Susquehanna Hose Company. He lost his life to cancer. We don't want to lose any more firefighters to cancer, or at least reduce as much as we can. And that's what this bill is about. We have 2 gentlemen here, both from the fire service, that would like to testify. So, Madam Chair, with that, I ask for favorable consideration on this piece of legislation.
Thank you, Senator. Who would like to start?
Sure, I'll go ahead. Good afternoon, Chair Bidle, Vice Chair Hayes, and member of the Senate Finance Committee. My name is Dale Bowen, representing the Maryland State Firefighters Association, and I'm also in my 40th year with the Huntingtown Volunteer Fire Department and Rescue Squad in Calvert County. The MSFA fully supports Senate Bill 579. Cancer remains one of the leading causes of death within the fire service community. Early detection through regular preventative screenings greatly improves long-term outcomes and survival rates for firefighters. The state currently provides a cancer screening fund and grant program intended to help pay for cancer screenings for members of the fire service community. Unfortunately, the Maryland Department of Health guidelines made it very difficult for the volunteers, and the fire departments have experienced significant challenges with this program. Senate Bill 579 would shift the responsibility to local governments to provide these cancer screenings while allowing counties to apply for reimbursement through the state's Cancer Screening Fund. This approach would streamline the process and greatly improve participation among volunteer fire departments in this critical preventative health program. Providing consistent and accessible cancer screening for firefighters is an essential step towards protecting the health and safety of those who dedicate their lives to protect our communities. For these reasons, the MSFA respectfully requests a favorable report on Senate Bill 579. Thank you, and I'll take any questions if you have them.
Thank you. We'll finish with Matthew, and then we'll come back for questions. Thank you. Matthew Fox.
Good afternoon, Chair Bidle and Honorable Vice Chair Hayes, and members of the Senate Finance Committee. My name is Matt Fox, and I'm a career firefighter. I'm here to testify in support of Senate Bill 579, which would require free cancer screening for volunteer firefighters. Like many firefighters, I began my fire service at the Chestnut Ridge Volunteer Fire Company in Owings Mills in Baltimore County. I wanted to help my neighbors and show up when someone in my community was having their worst day. I'm still an active member of the Jacksonville Volunteer Fire Company. In Maryland, volunteer firefighters make up more than 60% of the fire service, over 25,000 individuals. In response to the fires, breathe the same toxic smoke and face the same carcinogenic exposures as career firefighters. Carcinogens don't care whether you receive a paycheck. Firefighters are diagnosed with cancer nearly 7 years earlier than the general population, showing a career connection between our work and the illnesses. Between 2002 and 2019, 66% of career firefighters' line of duty deaths were caused by cancer. Last year, Maryland required counties to provide free cancer screening for career firefighters through insurance. Senate Bill 579 extends the same protection to the volunteers who serve beside us. Volunteer firefighters protect our communities every day and ask for very little in return. Early cancer detection is simply a step that can save lives. I respectfully urge the committee to vote in favor of Senate Bill 579. Thank you for your time and consideration. And if you have any questions, please let me know.
Thank you, and thank you both for your service. Very much appreciate it. Do I have any questions for the senator or for Matthew or Dale? I don't see any questions. Senator Mounts.
I'll be very quick, Madam Chair. How many times has this program, how many times have you, since this program has been put in place, are you, I don't know if you know accurately or if you have to guess, but how many times has this program changed since it's been put in place where you've tried to get into the program and then it was either pulled back or changed or that sort of thing?
Well, I can speak mainly for this year, this round of testing. The first round, the testing was open in the middle of November of last year. Was only open for a month for people to apply. And as soon as the application process was closed, the program was shut down. It was reconfigured, opened back up for more rounds of applications with new guidelines. And this is through the Maryland Department of Health, by the way. Unfortunately, some local volunteer fire departments aren't as good administratively at getting these things filled out on time and getting the proper documentation that they need. And it made it very difficult for volunteer fire departments. I think the last round of testing, I believe only one volunteer fire department in the state ended up with a grant.
Yeah. So I've got like 26 in my district.
Yes.
So
It's very difficult to apply.
Thank you.
Through it now.
Senator, you might like the fiscal note when you have time to look at that. So thank you all for your testimony. Senator's going back to his committee. Thank you very much.
My vice chairman's calling me.
Thank you. That ends the hearing.
Thank you.
And now we're going to go to Senate Bill 702, Senator Mounts, because you'll be leaving for another committee. So I think you have Jeannie Hadaway-Riccio with you.
We had an emergency.
And is she, I know about one of them. Is somebody with you?
Yes.
Okay. Go ahead, whoever's here. Thank you.
She's in the other committee, Johnny.
Thank you, Madam Chair. It's my honor to present Senate Bill 702, which clarifies the requirements for the relocation of behavioral health centers. This legislation was spawned, I guess you would say, after an occasion where we had a situation in our district where For All Seasons, which is what a constituent behavioral health provider, had set up in downtown Cambridge, and they had met all the needs, met all the goals, met all the requirements, and yet they had staff and they had property and they had everything ready to go, and they sat vacant for a month or so. And so what this legislation does, is it cleans up that process to make it quicker so these agencies can relocate. And with that, I'd turn over the microphone to our expert witness, Mr. Ryan Snow.
Thank you, Senator. Good afternoon, Chair Bidle, Vice Chair Hayes, and members of the committee. Great to see you. On behalf of For All Seasons, I'm here in support of this bill, Behavioral Health Administration, relocation of regulations. This legislation would require the BHA to adopt regulations authorizing the program to relocate to another site. Currently, they require established providers that are relocating their offices to apply for approval as a new applicant rather than providing a separate, more streamlined process for a simple address change. For All Seasons is a licensed behavioral health and rape crisis victim center that has served the state of Maryland for 40 years and provides services to 5 counties on the Midshore. They were recently impacted by this, as the senator alluded to, and as a result were required to maintain 2 offices, adding significant financial burden to keep 2 leases at the same time. To avoid these delays in the future, we recommend that a distinct and expedited process for a simple change in address request be created for existing licensed providers that are in good standing with the Behavioral Health Administration. And for these reasons, we respectfully urge a favorable report from the committee.
Thank you, Ryan. I do want to read to you a letter we have from the Secretary of Health.
Okay.
You know, sometimes bills create discussion, conversation. So she writes, the department plans to include regulatory provisions that allow for a streamlined application process for providers who are relocating or adding an additional program site. So you'll have it. Thank you.
Thank you very much.
Thank you, Senator. Senator Love?
Yes,
We're going to do Senate Bill 907. You're going to bring up your panel, Susan Rubel, Karen McDonald, Jeju Coyote, Alicia Miles, and Sorrenta Candle. There we go. Thank you all. Senate Bill 907.
Thank you, Madam Chair, Mr. Vice Chair, members of the Finance Committee. It is a pleasure to be in front of you today. I don't normally get here, so I'll share one little embarrassing thing with you. I went across the hallway into Tripoli, and I was talking to Secretary Hadaway Riccio, and she said, "Oh, it's great to see you here. We're going to talk about oysters." And I went, "Oh, goodness, wrong committee." So glad that I made it on time. For the record, Senator Sarah Love here to present to you SB 907 relating to female genital mutilation or cutting, which I will shorten to FGMC. FGMC is a violent and disturbing violation of bodily autonomy and human rights. According to the World Health Organization, FGMC, quote, violates a person's right to health, security, and physical integrity, and the right to be free from torture and cruel, inhuman, or degrading treatment. Maryland banned FGMC in 1998, and when we did so, we were a leader in the nation. However, we are now far behind, and SB 907 would update our law. It would strengthen protections for victims of FGMC, and it would also require education. So this is not a problem that is done somewhere else that affects people somewhere else, people far, far away. This is an issue that affects Marylanders. In fact, about 25,000 individuals are or are at risk of becoming victims of FGMC. And girls from infancy to age 15 are at the highest risk. Impacts of FGMC are severe and detrimental, both physically and psychologically. Physically, there are short-term and long-term effects. Short-term, victims face severe pain, excessive bleeding, shock, infections, and even death. In the long term, victims are at risk of continual chronic infections, childbirth complications, and more. Psychologically, victims are at risk of PTSD, anxiety, depression, sleep disorders, and persistent feelings of anxiety, anger, loneliness, guilt, or shame. Current Maryland law addressing this, as I said, is outdated, and the protections it provides are insufficient, causing easily exploitable loopholes. For example, people can take young girls and women out of the state out of the country for what's called vacation cutting. And you'll hear some of that testimony later. SB 907 would close that loophole. It also strengthens our laws in a number of other ways. First, it defines in law FGMC as the abuse that it is. Second, it strengthens consequences. Victims would have the ability to sue their abusers. It would require that medical providers who are convicted of FGMC lose their licenses. It also increases the maximum penalties to reflect the harm that it causes on victims. And finally, research has shown that legislation alone is not enough to change the societal norms in the communities that use and perpetuate FGMC. Education about the practice is key in preventing it from happening in the first place. So SB 907 would fill that education gap. FGMC is a human rights violation and a violent abuse on girls and women. And for these reasons, I respectfully request a favorable report on SB 907. Thank you.
Thank you, Senator. Who would like to go next?
I'll go first.
Okay.
Good afternoon, Chair Beidel, Vice Chair Hayes, Senator Love, and members of the Finance Committee. My name is Dr. Karen McDonald, and I am representing the DMV Coalition to End Female Genital Mutilation and Cutting. Oh, yep. There we go. Can you hear me now? Oh, okay. I am a Maryland resident and a tenured associate professor in public health. I've spent the past decade working with survivors of FGMC and the healthcare providers who treat them. In my professional capacity, I've also worked on the Federal Stop FGM Act of 2020. And I'm here today to express my strong support for SB 907, entitled Public Health, Female Genital Mutilation, and to urge a favorable vote. As you've heard, FGMC is a total or partial removal of the external female genitalia or other injury to the female genital organs for non-medical reasons. This is a severe human rights violation. It results in lifelong physical and psychological trauma, including chronic pain, infections, and complications in childbirth. Right now, our region has the second highest prevalence in the country. More than 30,000 women and girls in Maryland are living as survivors or are currently at risk. While Maryland was a leader in 1998, our laws are now outdated and leave survivors vulnerable. SB 907 is the holistic update that we need. It builds on our history by aligning our definition of FGMC with the World Health Organization. It explicitly recognizes FGMC for what it is, a form of abuse, to ensure mandatory reporting. It prohibits vacation cutting. It mandates community education and outreach. And it provides survivors the right to civil action right here in Maryland. We have the opportunity today to close these gaps and provide a comprehensive public health response that protects girls and supports survivors. I fully support this bill and respectfully urge the committee to move SB 907 forward immediately. Thank you for your time and your consideration.
Chair Beidel, Vice Chair Hayes, and members of the Senate Finance Committee, I'm a licensed clinical psychologist, born in the United States and grew up in Maryland. I'm a survivor of female genital mutilation, FGMC, that took place when I was a child on a brief trip out of the country. I'm Dr. Lisa Miles, and I've lived with the repercussions of what happened for the rest of my life. I was once a child who didn't know of any such thing as FGMC. I was born to parents from a Muslim sect called the Dawoodi Bohras, a group known for carrying out FGMC. It was never spoken about, not at home or at religious gatherings. I didn't know adults kept this practice hidden and secret. While I was going to kindergarten and first grade, I didn't know my family members were looking for someone to do this to me. No law prohibited it then. First, the licensed pediatrician, who was my doctor, was asked. He said he didn't offer this, but said nothing to deter the search. Then, through a family connection, another Maryland doctor was asked, and it was conveyed that though he may have performed FGMC in the past, he no longer offered this to parents looking to have this done to their child. I learned these things only in adulthood. After I had just finished first grade, I was taken to Pakistan on a trip. That summer, something horrible happened that made me never want to go back there. Something I didn't understand, had no words for, didn't ask for, was never explained to me during or after, and something I would never allow to happen to me or any other human being if I had any choice. But I was 6 years old. I was then brought back to Maryland, my body altered without my permission. Through all my years of elementary and middle and even attending one of the largest public high schools in Maryland, I never learned about what happened to me. At college, I learned about FGMC from a book I picked up in a bookstore. And then I remembered being 6 and being in Pakistan. Then a family member confirmed that it did happen. I remembered being far away from home, and when it happened, I didn't know where I was.
Dr. Miles, will you just finish? I'd like to hear the rest of your story, please.
I didn't know where I was, and I didn't know how to find anyone to turn to or any place to go for safety. I have only been able to become able to speak about this recently in my adulthood. I experienced many of the typical symptoms of post-traumatic stress, but many therapists were unprepared and unable to help address this. During college, when I went to the only clinical psychologist on campus, he told me he was not trained to help with this, and maybe when I went to grad school, I could find help. He never spoke with me about it again. After decades of therapy, much of which I paid for out of pocket, I finally found some help with this trauma around the age of 40. I live now and work as a psychologist where I treat many survivors of severe trauma. This legislation you can now pass would help protect and support Maryland's children and other survivors from this violation of their human rights. If this legislation and awareness and education and support had been available when I was younger, my life would have been different and full of much less suffering. Thank you, and I urge a favorable report.
Thank you for sharing your story. It's very sad, but it sounds like you're helping other people, so maybe that's the benefit. But thank you very much for sharing your story. Who's next?
Good afternoon. My name is Jesu Kuyate. I'm here to testify on SB 907. I'm also senior representative of the Ministry of Planning and International Cooperation of Guinea to the Bretton Woods Institution here in Washington. And I'm also the executive director of Inter-African Committee USA, an organization established in 2006 to raise awareness and educate American and diaspora community about harmful traditional practices, particularly female genital mutilation, CADI, which severely impact the life of women and children. The guiding principle of IAC USA is education in order to bring a positive change of attitude and capacity building of affecting communities. Our mission is the promotion of gender equality and contribution to the improvement of health, status, social economy, political, human rights, and quality of life of women and children through elimination of harmful traditional practices and the promotion of beneficial one, particularly inter-African community worldwide. I would like to share a brief but a heartbreaking story about what often called vacation cutting, which highlight the urgent need for stronger protection. A survivor of FGM was married to an American man living in Maryland. Her husband had been married twice, but did not have children from those previous marriages. When he met this beautiful woman, they fell in love, but they were blessed with beautiful girls. Since the family of the lady had didn't have a chance to meet their daughter, she asked if she could take the girl to visit her relative back home. At first, the husband was hesitant, but eventually he agreed, asking her to watch over the girl. Since the relative knew that the daughter had not undergone FGM procedure, they forced FGM on her while she was absent. The girl was suffer from severe bleeding and tragically lost her life. This story reminds us that girls are especially vulnerable during school break or when they are traveled to where these practices take place. Now it is time to strengthen Maryland law and send a clear message that we will protect women and girls and prevent tragedy like this from happening again. Passing this bill will really save lives. Thank you.
Good afternoon, and I just want to say I'm really honored to be here in front of you guys today. My name is Sarata Kande, and I'm a woman that wears many hats. I'm an entrepreneur, a businesswoman, a mentor of inter-African community. Before I was that, I was a little girl. Imagine being excited, all dressed up, being told that you're going to a birthday party with your cousins. At least that's what I was told. I remember sitting in the van with my cousins, all smiling and excited. But when we arrived, it was not a birthday party. We were taken to a nearby bush, in line, waiting for our turn. I was frightened and confused. As I wait, I can hear the girl before me scream. When it was my turn, I was pinned down with a lady who held her hand around my face, while the others sang songs that welcomed me to womanhood. This experience was very intense and very traumatizing. It wasn't until later in life that I learned what had happened to me. What was taken away from me was the most sensitive part and essential part of my body as a woman. This trauma did not only end that day. For years, I have endured many menstrual cycle periods. For the first year of my marriage, I went to the hospital 10 times a month. 10 times, that's almost every month for the year. I thought also the thought of failure marriage because I was the blame of infertility. This caused me to have many chronic pains, infections, and many, many more depression and mental illness, which I really had wished I had more than two minutes to express. This is a pain in many of us reality, and we're told that it's a taboo to talk about, especially to be in the room full of powerful people like you guys to hear our story. Please take our bill into consideration. Thank you.
Thank you.
My name is Susan Rubel. I'm a Maryland resident, and I spent 35 years working as a prosecutor for the U.S. Department of Justice. Part of my work there included investigating and prosecuting perpetrators of FGMC. As you've heard today, FGMC is recognized as a human rights violation around the world. In the United States, it's been a crime since 1996. You've also heard that Maryland was one of the first states to also ban the practice in 1998. Today, 41 states, including D.C. and Virginia, also ban the practice. The question before you today is whether Maryland's statute, written nearly 3 decades ago, is sufficient to protect girls, given what we now know about the practice. In my opinion, it is not. Although federal law has been strengthened twice since its passage, Maryland's law has not kept pace. First, Congress amended the law to ban vacation cutting, which you've heard about today from 2 women who underwent it themselves. Most state laws also now prohibit taking a minor out of the state for FGMC. Second, Congress expanded the definition of FGMC so that it aligns with the definition used by the World Health Organization, ensuring that the full range of potential conduct is covered. Third, Congress increased the maximum penalty from 5 to 10 years in prison, reflecting the seriousness of this crime. This bill addresses each of these issues and brings Maryland law into line with the federal law. Most importantly, prosecution is not the way to end this practice. The bill's provisions add mandated reporting and education for service providers, and those are equally important components. They will ensure that girls at risk can be identified before harm occurs. Maryland was an early leader in protecting girls from this practice. Passing this bill will enable it to remain effective in doing so. Please vote yes on SB 907. Thank you.
Thank you for your testimony. Do I have any questions for this panel? Very sad stories, but thank you. Thank you all for testifying. We have one more person to testify in favor of the bill. You have lots of people in favor of the bill. I think we're going to be able to get this passed. Lysae?
Thank you. Good afternoon, Madam Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We are here in strong support of Senate Bill 907. This is my only time in the Finance Committee this session, so let me please also take the opportunity to thank the chair for all of her work on behalf of women and girls during the course of your career. Senate Bill 907 is another one of those bills. Female genital mutilation and cutting is sexual violence. All sexual violence leaves emotional scars. FGMC leaves permanent, irreversible physical scars and is designed to limit women's sexuality. Critically, this bill addresses this by criminal civil remedies. It addresses licensing for healthcare professionals, mandated reporting, and also provides for community education. You've already heard from the other witnesses the many reasons this bill should be reported favorably. I will say, if anything, looking at the other penalties for sex crimes, the penalties are too low. But I urge a favorable report, and again, thank the chair for all of her work.
Lisa, thank you. Thank you for all your work. Do I have any questions for Lisa? Thank you very much. That ends the hearing for Senate Bill 907. We're going to go to Senator Washington, Senate Bill 870. And you have one witness, Senator. It's Stephanie Slowly Little.
There's one other person from the county council.
I don't see it, but that's
Yes, sir.
fine.
Okay. Thank you, Madam Chair. Appreciate the indulgence. You want to sit right there?
One time.
Thank you, Madam Chair, members of the committee. For the record, Senator Alonzo Washington here to present on Senate Bill 870, the Maryland Department of Health Adolescent and Psychiatric Inpatient Bed Capacity in Prince George's County and report. This bill requires the Department of Health, in consultation with the Prince George's County Local Behavioral Health Authority, to ensure at least 24 licensed adolescent inpatient psychiatric beds in Prince George's County. It requires those beds to be fully operational by December 31, 2028, certain deadline. It requires a backup procurement pathway if the beds cannot be delivered through expansion in time. MDH must issue an RFP by June 30th, 2027. It prioritizes solutions that reduce boarding and ensure access regardless of payer source, including Medicaid. And finally, it creates a competitive grant tool focused on capital and startup needs that actually make beds possible. With your indulgence, Madam Chair, I'm going to stop my testimony and then read one of my constituents' testimony who was the impetus for this bill, that lives in my district, that worked really hard to work with me and my delegates because she had this, because of her, we're here today. So I'm just going to read her testimony, if that's okay. She couldn't be here today because she's at work and couldn't take off work because she has to take care of her child. My name is I'm reading in her testimony. My name is Danielle Leclerc. I am testifying today in favor of SB 870, which would finally bring critically needed mental health services for kids to Prince George's County. I adopted my daughter Patience from foster care when she was 9 years old. Patience has a significant history of trauma from her birth and foster families and serious mental diagnoses, including PTSD and depression. We live in Prince George's County. Unfortunately, Patience has needed the hospitalization for mental health treatment a number of times. Even worse, due to a shortage of inpatient psychiatric hospital beds for treating kids and teens, Patience's health has been actually made worse on multiple occasions. Patience has boarded or stayed for a prolonged period of time at several emergency rooms, including one stay of 10 days and once when an ER moved her to another hospital without telling me. None of those ERs had pediatric ER areas, so Patience was exposed to some really scary things, including adult men at the same ER area with mental health issues, people coming in with heart attacks and from car crashes and more. This is terrifying for a child, especially one with a history of trauma and PTSD. Due to a shortage of inpatient psychiatric beds in Maryland, Patience has had to go to DC, Pennsylvania, and even Utah for life-saving mental health treatment. Some of this was covered by insurance and some was not. Even when Patience was able to get admitted to a hospital in Maryland, she was often an hour or more away from home in Baltimore City, in Calvert County, and in Frostburg, and even which is in Allegheny County. That meant I had to travel extremely long distances to visit her. When you are a worried mom, the last thing you need is a 2-hour round trip drive to visit your child at a hospital. While this bill will require a new inpatient hospital beds for psychiatric care for teens in Prince George's County, this bill will help all children facing mental health issues in our state who need inpatient care. This is because there is a serious shortage of inpatient psychiatric beds for kids and teens in our whole state. Opening 24 beds in my county will mean that kids who live in Baltimore area can hopefully get treated in Baltimore. Kids in Southern Maryland can get treated there. Further, there are fewer than 10 hospital overstay beds at Brook Lane for kids in the entire state. Maryland closed Salem Trust in Frostburg about 4 years ago, leaving only a few beds at Brook Lane for kids who need extended mental health hospitalizations. I want to close by sharing one really scary story. 2 years ago, when Patience was 16 years old, Patience was hospitalized 3 times in 2 months for mental health care. I begged every department in Maryland for help. Developmental Disabilities Administration, Department of Behavioral Health, etc. I was finally told that DDA had a short-term program where kids like patients with serious mental issues and developmental disabilities could be placed in an apartment in Baltimore City, an hour from her home, with just one aide outside her door. No treatment was offered, just minimal supervision. I agonized at the time what to do. Ultimately, I declined the offer, and my incredible delegates and senator from my district, District 22, and my county council member helped me find resources. I was able to get Patience in a long-term mental health program. I am glad to say that her mental health has improved somewhat since then. But when I read the story of the death of Miss Kanaya Ward last fall, she was alone in a hotel room in Baltimore. I broke down in tears. Just like Patience, Kanaya was 16 years old. Just like Patience, Kanaya needed life-saving mental health care. Just like Patience, Kanaya lived in Prince George's County. Just like Patience, Kanaya's mom was not given the opportunity to have her daughter be treated in the hospital, and instead was only offered lodging in a hotel and an hour away with one aide as a last resort to help her daughter. The only difference is that Kanaya died alone in a hotel instead of getting life-saving treatment at a hospital. And my child is alive today. I grieve with Kanaya's mom and everyone who loved her. The same tragedy could absolutely have happened to my child. Madam Chair and the members of the committee, for Patient's story, for the story of Danielle LeClaire, I asked for a favor report on creating more psychiatric inpatient beds in Prince George's County. Thank you, Madam Chair.
Thank you, Senator, and these are needed all over the state. Right now, we have 32 kids in overstay.
Yep.
Not getting help that they need, so thank you for bringing the bill. I don't know this gentleman's name.
Greetings. I'm Jabari Cooper here on behalf of the Prince George's County Council. Greetings, Chair Vital and members of the Senate Finance Committee. On behalf of the Prince George's County Council, we respectfully submit this testimony in support of Senate Bill 870, which will require the Maryland Department of Health to ensure the establishment and ongoing operation of a minimum number of licensed adolescent psychiatric inpatient beds in Prince George's County, and to evaluate options for expanding capacity when needed. Prince George's County is home to one of the largest youth populations in the state, yet families continue to face significant challenges accessing timely and patient behavioral health services for adolescents experiencing acute mental health crisis. A limited bed availability often results in extended emergencies, department boarding delayed, treatment, and families being forced to seek care outside of their home jurisdictions. Expanding local inpatient capacity is essential to ensuring that youth receive appropriate, timely care in the least disruptive setting possible. Senate Bill 870 addresses a critical gap in Maryland's behavioral health infrastructure by prioritizing geographic equity and access to inpatient psychiatric services. Ensuring sufficient adolescent bed capacity within Prince George's County will help reduce strain on emergency departments, improve continuity of care, and support better outcomes for youth and families. Increased local capacity also enhances a coordination with community-based providers, schools, family, and support systems, which are all vital components of effective behavioral health treatment. From a local government perspective, improving access to adolescent behavioral health services can also reduce downstream impacts on public health safety systems, school systems, and social services. When youth are unable to access appropriate care in a timely manner, local systems often absorb the consequences through increased crisis response demands and service utilizations. Senate Bill 870 represents an important step towards strengthening Maryland's behavioral health continuum and ensuring that Prince George's County residents have equitable access to needed services. For these reasons, Prince George's County Council respectfully urges a favorable report for Senate Bill 870. Thank you.
Thank you. Are you the council member?
I am not the council member. I'm a legislative director and a legislative officer.
Thank
well,
you.
committee director, legislative officer.
I just wanted to know if I was addressing you properly, so thank you. And then Stephanie, you're last. Yes.
So good afternoon, Chair Bidle, Vice Chair Hayes, and the distinguished members of the Finance Committee. My name is Stephanie Soley-Little. I have the pleasure of serving as the Executive Director for NAMI Maryland. My organization represents 11 local affiliates inclusive of Prince George's County, and we represent over 60,000 families, individuals, and community-based organizations that serve people who are living with and support those who have mental health needs. We strongly support the Senate Bill 870 with the understanding and recognition that we need comprehensive and statewide support for our youth regarding inpatient stays. I would like to contextualize my statements by a few things that have not been addressed by the sponsor as well as the council. There's a distinguishing factor when we talk about supporting youth, when we are looking at mental health support versus behavioral health support, which is inclusive of substance use. I would like to highlight for the committee that we need to be honed in on what mental health looks like and treating those with mental health needs. There's a nuance when we talk about behavioral health. I think people suffer with substance use, I think people deal with mental health, and I think people deal with both. And there's not a lot of support leaning towards mental health services. And I think we have to really hone in on what that is. That's being proactive, that's being investing and trying to go upstream and address the needs of that. When we talk about communities such as Prince George's County, which I am a member of, it is really a dire strait in terms of comprehensive services that we can give. And as a testimony that was written and submitted by one of the leading constituents of our county, it really highlights the fact that we need to be able to support people in the county in which they reside, especially when we're talking about children in their most vulnerable states. I would like to also underpin the need to ensure that I know that the Assembly as a whole are looking at how to address behavioral health services and psychiatric beds, but we really need to focus in on mental health services specifically and how we address it in counties such as ours. So for this reason and many more, we just strongly urge the support of this bill, and I thank you for your time and attention.
Thank you. Do I have any questions for the sponsor of this panel? I don't see any. Thank you very much.
Thank you.
That ends the hearing. Senator Giles is going to take over. I'm going to do Senate Bill 90.
Madam Chair, you just had Mr. Buttle on your panel and no one else? Okay.
No one else.
Okay.
Everybody was favorable with amendment.
Okay.
I think Mr. Buttle and I worked things out at 1:15 today. So.
Perfect timing. All right. Feel free to get started whenever you're ready.
Thank you, Madam Chair. Senate Bill 90, Workmen's Compensation is Occupational Disease Presumption. So many years ago, when I was in the House, we passed a bill that gave firefighters the presumption for hypertension, meaning that we know that they're prone to hypertension because of the work they do, the stress, the crazy hours, the lack of sleep, all those things. And so we know for sure that they do have a presumption for hypertension. The problem has been, it's been deemed that they needed to miss at least 3 days of work to be considered disabled. And we've all heard this bill many years. And so I made a decision during the interim that we needed to do something to fix the problem and to stop hearing the bill. And so working with our counsel, Nathan McCurdy, we drafted a bill. And there was some issues that I worked with today with Mr. Buttle. But what it says is our firefighters do not need to miss work to be considered presumed that they have hypertension related to their job. And so Senate Bill 90 establishes that certain firefighters and other first responders are presumed to have an occupation's disease suffered in the line of duty and are presumed to be disabled if the individual has been diagnosed with hypertension, has been prescribed medication to treat that hypertension for at least 90 days, has served in their role for at least 2 years, and are still serving at the time their claim is filed. And so the presumption of disability is a critical component of the bill because what we're seeing is that the commissioners in Workmen's compensation hearings are determining that because some of the first responders are not missing work or not missing enough work, they're not partially or totally disabled, which is a requirement for the hypertension presumption under current law. Our firefighters service daily in the most dangerous of situations, and I respectfully request a favorable report on Senate Bill 90. And Mr. Buttle's going to talk about the amendment we agreed on today. So thank you.
All right, thank you. Go ahead, Mr. Buttle.
Thank you, Senator. For the record, Jeff Buttle, President of the Professional Firefighters of Maryland. We represent approximately 10,000 active and retired professional firefighters and emergency medical services workers across the state of Maryland. Just to clarify, I did sign up favorable with amendment. The chair is right. We've been trying to deal with this issue. I think this is the fourth year. It's been before the committee. I think she did a really good job explaining what the issue was and what some of our firefighters are running into to try to get covered under the current presumption law. And I think it's important to remember hypertension is currently a presumption. It was one of our original presumptions that we actually added back in the 1970s. It's only been in recent years that we've ran into some of the issues with what constitutes disablement for hypertension. And that's what this bill is addressing. There were a few amendments that I was going to talk about. I had a good meeting with the chair. We're going to work those amendments up and work those out. So I will just say, first I want to thank the chair for taking this issue up. It's a really important one. It's been around for a couple years. We'll fix some of the original language in the bill, working with the chair and legal counsel, and we'll make sure that everybody's on board with that and get those distributed to the committee, which is they're being worked on right now. So with that, I do encourage a favorable report with the amendments that we will work out with the chair of the committee. And thank you for your time today, Senator.
Thank you very much. Do I have any questions for Senator, for Madam Chair and her panel? Mr. Buttle? None. Seeing none. Thank you.
All right. Thank you.
Everybody's in other committees.
All right. Next, we have Matthew Darby, Mike Daly, Julie Murray, Charles Schultz, John Hall, we also have Ashley Smith, who was signed up unfavorable, but we got everybody else with the Defense Council for favorable with amendments. So I assume you're also favorable with amendments?
That's correct.
That's correct. Okay, great.
My apologies. I was on vacation and I was signed up by my assistant.
No worries. I hope you were somewhere good.
I was in Morocco and it was fabulous.
Okay, great. All right. Whoever wants to get started, go right ahead.
Okay, I guess we can start on this side. Good afternoon, members of the committee. My name is Matt Darby. I'm a practicing attorney here in Maryland, and for many, many years, more than I sometimes care to remember, I've represented firefighters and dealt with many of the presumption hypertension cases that were so capably described by our prior panel. I think this is a good resolution to the issue. One point I would make is with respect to one section of the bill that talks about the claim application section of the bill that requires the firefighter to actually file the claim while they were still active as firefighters. I would suggest that that may be more than is necessary. Many of our firefighters who have hypertension are diagnosed while they are active and would meet the other requirements of disablement as defined by this bill, but may not file the claim for many years after their retirement. The way that the statute of limitations works in these cases is that the statute of limitations doesn't begin to run until the firefighter has actual knowledge that the condition is related to their employment. So the key is that the bill tries to accomplish is to make sure that an active firefighter has a different disablement definition than retirees. But I think the key point is when they had the disablement, were they active, regardless of when they filed the claim. So one amendment that I would ask the committee to consider is to change the date from claim application to date of disablement, that the firefighter be active at that time. And thank you.
Thank you very much.
Thank you. Good afternoon. My name is Charlie Schultz. I'm an attorney with Berman, Sobin, and Gross, and we represent firefighters across the state of Maryland, have been for many years. I'm here to testify favorable with amendments on Senate Bill 90, and I second Mr. Darby's comments, and we're excited to, in year 4, finally get this bill through. The comments that Mr. Darby made about the disabled, that is a concern that we have, and frankly, using that new diagnosis or definition rather as a sword instead of a shield is something that we would like to try and avoid. And also, as a whole, not to overcomplicate the law as it stands now. So as we work together with all sides here to try and put through this new definition of disablement for hypertension, not to make the job for the commissioners and the practitioners even harder than it already is. We want to simplify this process so that we have consistent results at the commission level. Thank you.
Thank you very much. Julie?
Thank you. Good afternoon, members of the committee. Julie Murray on behalf of Maryland Defense Council. We are also favorable with amendments on this bill because we understand the need based on years past to pass some type of legislation that addresses the issue pertaining to disablement as it relates to medication only. The only amendment that MDC is proposing is essentially to bring the 2-year statute of limitations within the confines of this new definition. This ensures that the bill remains consistent with our other parts of the act. What this bill essentially does is it doesn't limit a person's ability to claim disablement, but it creates a second pathway to disablement. So in other words, if you have a paid firefighter who meets the criteria in the bill, they now have a way to achieve disablement if they are prescribed medications and take them for a period of 90 days under the bill. And so essentially what we are proposing that it would need to do is also require those people to make their claim within 2 years of the 90th consecutive day of being prescribed medication, essentially just to create some parameters around that. We understand that by creating this bill, we're essentially adopting a lower evidentiary threshold for certain classes of firefighters who have to take medication only in order for them to be disabled. In exchange for that, our proposed amendment would essentially just include some level of boundaries and predictability for people that qualify under the section. So we look forward to, as well, working with everybody to hopefully come to some agreements on some amendments that make this bill good for both sides. Thank you.
Thank you. Mike?
Good afternoon, members of the committee. Mike Daly for the Maryland Defense Council. Along the lines that Ms. Murray was just discussing, the 2-year statute of limitations is what the law is already. The MDC would like to see that inserted in there so that it's clear that once the firefighter is diagnosed, already saw their physician, diagnosed with hypertension. We've heard that hypertension is well known within the firefighter community, that it's an unfortunate part of the job. So the knowledge part is already in there. They clearly are probably having discussions with their physician about, what could be the source of why they've got hypertension, especially perhaps at a younger age. So this gives them 90 days that they on the medication, and then starting day 91, they have 2 years from that date to file their claim. So they have plenty of time to make sure that they have every bit of information and everything they need in order to secure what they're entitled to. And as Ms. Murray said, this is just one different avenue for these firefighters to pursue. And so in this respect, we feel that amendment is consistent in terms of the history of the statute as well as what it already provides. We think it's just important to make sure that it's part of the statute now. Thank you.
Thank you. Ashley?
Thank you, Senator Guile and members of the committee. My name is Ashley Smith. I'm speaking for Maryland Defense Council. Maryland Defense Council submitted some proposed amendments to the bill. One of them is at the very end. It's Section 6. And essentially it states that we are in favor of these amendments proposed by the chair so long as the individual we want to make it clear that this bill creates two separate evidentiary pathways to achieve one hypertension claim. So we created some language at the end to make it clear that we are not creating two separate claims for hypertension. There is still only one hypertension claim, but an injured worker can choose which pathway to follow when in pursuit of those benefits. And this also will help us uphold one of the foundational aspects of the workers' compensation system, which is preventing duplicative benefits. It would prevent someone from filing two different hypertension claims using these foundational pathways differently and receiving double compensation. And that's the reason that we have proposed that final language just for clarification. Maryland Defense Counsel believes that these amendments, as well as the bill as submitted, are designed to address the firefighters' concerns regarding medication being made available to career firefighters and active duty firefighters who, as we know, are so critical to what we do in the state, and gives them this specific definition that they can avail themselves of. It's important to note that we are not taking anything away from the firefighters by giving them this reduced pathway to go forward. The existing law will still stand in effect. So if they are able to prove a traditional disablement as stated under case law, they will still have that option available to them. It's not like we are just limiting it to this shorter time period. Both pathways are an option. Thank you.
Thank you very much for your testimony. I am not seeing any questions for this panel, so that ends the bill hearing on Senate Bill 90.
Thank you.
Okay. All right, next, oh, Madam Chair's coming back up. I didn't even see you sitting back there.
Yep. So all right. Next we'll hear Senate Bill 522. It's Workman's Comp Evaluation of Permanent Impairments. I think we have someone from Senator Mary Washington's staff presenting the bill. Michael Joffrey, and then we have Mitchell Greenberg and Arthur Flax testifying. Thank you.
Good afternoon, Chair Beidle, Vice Chair Hayes, and members of this committee. For the record, I'm Michael Godfrey, Legislative Fellow for Senator Mary Washington, and I'm here to present Senate Bill 522. This committee has previously heard from Senator Washington's office regarding legislation to strengthen and advance the social work profession in Maryland. Senate Bill 522 continues that work. At its core, this bill is about parity. Licensed clinical social workers are trained to do the same standard of independent clinical practice as licensed psychologists, and this bill asks that Maryland's workers' compensation law reflect that reality. Right now, that law does not treat them equally. Workers' compensation claims can include a mental or behavioral health component, for example, a worker who develops PTSD or depression following a workplace injury. Currently, only licensed psychologists and qualified physicians may evaluate that portion of the claim. This bill adds licensed clinical social workers to that list. It's important to note that clinical social workers will not automatically be eligible to conduct these evaluations. They must also meet additional state requirements, including registration as a rehabilitation counselor or vocational evaluator with at least 2 years of experience in that role. Maryland is not breaking new ground here. Multiple states already allow clinical social workers to play formal roles in behavioral health evaluation for workers' compensation. In 2022, California passed legislation to expand the role of licensed clinical social workers as direct providers in the workers' compensation system with broad support from labor groups, employer associations, and professional organizations. New York's scope of practice statute for licensed clinical social workers explicitly covers the diagnosis and assessment of the psychosocial aspects of illness, injury, disability, and impairment, and clinical social workers there participate in workers' compensation evaluations. West Virginia's independent clinical social worker statute similarly authorizes LCSWs to evaluate and address psychological dysfunction, disability, and impairment. In closing, Senate Bill 522 extends formal recognition to a class of clinicians who are already performing behavioral health diagnosis and assessment at the highest level of independent practice. The experience requirements and vocational registration threshold ensure that only the most qualified LCSWs participate in this work. For injured workers, that means faster access to qualified evaluators and fewer delays in getting the benefits they are owed. Senator Washington thanks the committee for its consideration and urges a favorable report on SB 522.
Thank you.
Okay. My name is Arthur Flax. I'm a licensed certified social worker clinical. I am also an evaluator registered with the Workers' Compensation Commission, G0235. I've done work with the commission for many years and received referrals from the commission to do evaluations on disputed cases in the past. I've also been a referral source for both claimants' attorneys and defense counsel. The licensed certified social worker scope of practice includes the independent diagnosis, evaluation, and treatment of mental and emotional disorders and conditions, and impairments. It's specific in there, and it's affirmed by an Attorney General's advice of counsel dated January 25th, 2024, copy of which I submitted. Last year, when we presented the bill, we didn't have all the restrictions that we have now. One of the arguments that was raised by the opposition was that the clinical social worker did not have the authority to do a rating. It's at the same as is on a physical illness. COMAR 14090903 specifically states in here that a psychiatrist, physician, or psychologist does not have to do the numerical ratings in the same way that it's done for physical illness. If it is done, it's an option. And the fact is that clinical social workers, LCSWCs, have the authority to be able to do assessments and do clinical and do numerical ratings as may be required.
Thank you. And Mr. Greenberg?
Thank you. Good afternoon, Senator Bidle, Senator Hayes, and members of the Senate Finance Committee. My name is Mitch Greenberg, and I represent the Maryland Association for Justice. The MAJ is requesting a favorable report on this bill. I am also a claimant's attorney. I represent injured workers that have 35 years. What we have found over the years is that the pool of available experts is small and getting smaller. As they retire, there are very few psychiatrists left anymore who will evaluate claimants. There are fewer psychologists. And now we have clinical social workers. They are all skilled. Their training is phenomenal. They come before the commission and their opinions will be weighed. And usually the opinions, it gets you up to the table. It gets you up to bat. This would be a huge boon to the injured workers of Maryland, and we do request a favorable report.
Questions? Thank you very much. Oh, Senator Mouse, I didn't see it.
Very, very quick. I apologize, Madam Chair. And so we're doing legislations moving that would create this conditional social worker. Would they be excluded or?
They're excluded, sir.
Okay, thank you.
I was going to say very simply, the licensed certified social worker clinical is a separate license entirely.
Thank you for your question. Seeing no other questions, Michael, thank you for bringing up the bill. Thank you. We hope to see your senator back soon.
Yes, we do as well. Thank you.
I do have 3 unfavorables, Carmine D'Alessandro, Ashley Smith, and Michael Daly.
Thank you.
Carmine, you want to start? Or?
Yes, ma'am. Good afternoon, Madam Chair, members of the committee. For the record, my name is Carmine D'Alessandro. I am Chief Legal Officer for Chesapeake Employers Insurance Company and counsel to the Injured Workers Insurance Fund. Here to respectfully oppose Senate Bill 522. Like the last bill, this is the 5th or 6th year in a row we are here for this bill. It has been amended over previous editions, but the same flaws lead us to oppose once again. As I testified last year, the American Medical Association guides for impairment, which we use in addressing impairments in the workers' compensation setting, require that a physician or psychologist perform the rating. Based on that and the Maryland Rules of Evidence, Rule 5702, I brought a red book this year because Senator Ellis wanted one that matched some of the other ones. When a judge is assessing whether an individual can be an expert, the parameters in the American Medical Association guides would exclude someone that did not fit the definition of physician or psychologist in making these impairment ratings. And in closing, I want to stress, we're not saying that social workers can't testify. We're not saying that social workers can't be in the workers' compensation system. As you heard, they are routinely. There is one slice of the workers' compensation system that we were saying that they can't participate, and that's rating under the American Medical Association guides to permanent impairment, which is restricted to physicians and then physicians and psychologists when it comes to psychiatric impairments. And with that, we would request a unfavorable report. Thank you.
Thank you. Ashley?
Thank you, Madam Chair. Members of the committee, my name is Ashley Smith. I'm here to testify on behalf of Maryland Defense Counsel. I just want to say us too in regards to Mr. D'Alessandro's testimony, and also just emphasize that currently psychologists and psychiatrists are permitted to create these permanent impairment ratings. Both of those classes of providers possess a doctorate degree, just a different one. Some of them are MDs and some are PhDs, but they do hold a doctorate. My understanding of an LCSWC is that they do not possess a doctorate degree. Therefore, I do not believe they would be qualified to testify in circuit court should the case go on appeal. They would not be qualified to render any type of medical opinion in circuit court. And I think ultimately this bill, if it were permitted, would do a disservice to injured workers who are looking to get qualified impairment ratings from providers by essentially requiring them to have two different experts at the commission level and then at the circuit court. It could ultimately just end up hurting more than it helps. And to reiterate Mr. D'Alessandro's point, there is nothing that prevents an LCSWC from providing treatment, providing opinions on causal relationship, workability, things of those nature, which are fundamental to compensation claims. Unfortunately, they are excluded by the AMA guides, which are mandated by law. That is part of the Workers' Compensation Act, that they are required to use the 4th edition of the AMA guides. That's not, and to my knowledge, that's not something that's being reconsidered by anyone for any reason. So for that reason, we would request an unfavorable finding by the committee.
Michael?
Good afternoon, Madam Chair, members of the committee. Michael Daly for the Maryland Defense Counsel. Certainly, I just want to start by adopting Mr. D'Alessandro's and Ms. Smith's testimony. And as Mr. D'Alessandro touched on, there's a primary concern here. The decision of the Workers' Compensation Commission, and again, as Mr. D'Alessandro pointed out, this is just to the permanency portion of the Workers' Compensation Bill. When the person's done treating and they go before the commission saying that they have a percentage of permanent partial disability, either party can appeal that to the circuit court. Our Supreme Court adopted the U.S. Supreme Court's Daubert decision to determine whether or not an expert is qualified to testify. And it's clear based upon the AMA guides limitations that does not allow a social worker to provide a permanency impairment, that they would not be qualified under that Daubert standard. So you could have an injured worker who appeals the decision, and next thing you know, they don't even have an expert to testify in support of their appeal. The MDC certainly supports the work, the important work that social workers do in terms of assisting the injured worker in all aspects of their recovery and getting them to the point where they, are capable of going back into the workforce and their life continues on in a much better way. But for the reasons that we all just expressed, we respectfully request for an unfavorable report. Thank you so much.
Thank you. Do I have any questions for this panel? Seeing no questions, that ends the bill hearing. Before I go to the next bill, I want to thank two of our Workmen's Comp commissioners that are here, Mr. Forrester and Mr. Kittleman, if he's still here. Thank you. Thank you both for being here. We haven't had any questions of you yet, but I appreciate that you're here. I think we're going to go to Senator Reedy. Would you like to do your bill? That'll finish our Workmen's Comp bills for today. So, Senator, you're going to present. Yes, Senate Bill 449. Your panel is James DeWeese and Ashley Owens. Thank you.
The nick of time. From the other committee to this committee, back. Thank you, Madam Chair, and Finance Committee members. Great to be back before you. We're all moving around to different committees. I'm really glad to be in front of you today to present Senate Bill 449, which is a workers' compensation bill dealing with heart disease and hypertension presumption and permanent partial disability for Carroll County correctional deputies. I'm presenting this on behalf of Senator West and myself as the Carroll County senators. Senate Bill 449 authorizes an amendment to Maryland's workers' comp law to extend the presumption of compensability for heart disease and hypertension to Carroll County correctional deputies. Under existing Maryland law, certain public safety employees, including police officers and firefighters, are granted a legal presumption that heart disease or hypertension resulting in disability or death is an occupational disease related to their employment. However, for counties that have the jail as part of their that have corrections deputies as part of their sheriff's department, apparently you had to opt them in to the law for corrections deputies because I consider them to be law enforcement officers and police officers, of course, and they are, but they are a different category apparently. So this bill, they're not currently included in Carroll County with that statutory protection. So Senate Bill 449 addresses this gap by altering the definition of public safety employee within the labor and employment article to include Carroll County correctional deputies. Other counties have done this as well. Specifically, the bill adds Carroll County correctional deputies to the list of employees eligible for presumption of compensability under 9-503 of the labor and employment article. It includes correctional deputies under 9-628 for the purposes of workers' comp provisions related to permanent partial disability benefits, and it establishes eligibility requirements and documentation standards for deputies seeking this presumption. Under the legislation, if a correctional deputy suffers from heart disease or hypertension that results in partial disability or death, the condition will be presumed to be work-related unless the employer can demonstrate otherwise. This presumption ensures that they are able to receive workers' comp benefits that may include payment of medical costs related to the condition, reimbursement for lost wages during recovery, permanent disability benefits when an impairment prevents continued work, and death benefits for surviving family members in the event of a fatal occupational illness. I don't have to tell this committee, we deal with labor, we deal with corrections. Correctional deputies work in some of those demanding and high-stress environments that we can imagine. And I have more in my written testimony about this, but the physical and psychological stress that's associated with their duties is intense. And so this Senate Bill 449 simply extends the same recognition to correctional deputies serving in Carroll County that other public safety personnel have. It is a priority of our delegation. With me today is our Carroll County Sheriff, Jim DeWeese, and Ash Owens, who represents the Fraternal Order of Police Lodge 20 in Carroll County, and I'd like to have them give testimony, and then we're happy to answer any questions.
Thank you, Senator. Gentlemen.
Thank you, Madam Chair. I appreciate the opportunity to speak. Members of the Senate Finance Committee, I'm Carroll County Sheriff Jim DeWeese. As the sheriff of my county, I oversee both law enforcement and corrections. Additionally, I'm a retired captain with the Maryland State Police. I have a staff of 86 correctional deputies that serve the detention center. Our jail has a designated capacity of 185 inmates and regularly stays at capacity or above. We house anyone local that has been charged with a crime or waiting trial, or anyone that has been sentenced to 18 months or less. Our jail is a stressful environment, and my deputies take their jobs seriously with safeguarding the health and safety of all the inmate population, the civilians and contractors that work in our facility, and each deputy that works in the jail each and every day. Unfortunately, high blood pressure and heart disease is synonymous with public safety and corrections. The job is stressful, and deputies are required to be on full alert 24/7, 365. My office has done a lot over the past several years to combat the stress and presumptive heart issue associated with this job. We hold health clinics and provide incentives for deputies that get screened by our county health care provider. We applied for and received a grant for any deputy over the age of 40 to get a calcium scoring. And I'll tell you, if you're over the age of 40, get a calcium scoring, it'll save your life. These two measures have helped us save lives. We were able to identify several deputies that were all but walking heart attacks. Deputies that were in excellent shape but failed to recognize the stress of the job and their pending heart issues. In 2 cases, the deputies were literally steps from having a heart attack and dying, but our preventative efforts saved their lives. Our patrol deputies and firefighters in our county have the presumption of heart disease, but our correctional deputies, the unsung heroes of our public safety profession, don't. Your favorable report supporting this bill will ensure deputies that are diagnosed with heart disease are able to access life-saving benefits. Thank you.
Do you want to testify? Go ahead.
Good afternoon, Honorable Chair and members of the committee. My name is Ash Owens. I'm the president of the Carroll County Fraternal Order of Police. Our organization also represents correctional deputies employed at the Carroll County Detention Center. I'm testifying today in support of Senate Bill 0449, which would extend workers' compensation protections for heart disease and hypertension to correctional deputies in Carroll County. In the field of public safety, we often think about law enforcement, fire, EMS. Unfortunately, corrections professionals are all too often overlooked. It is recognized that police, fire, and EMS have a very difficult job that causes stress, trauma, and various physical ailments due to the nature of the work. So much so that Maryland legislation recognized this when they enacted the Labor and Employment Statute 9503, providing presumptive occupational disease protections for police and firefighters for such things as hypertension and heart disease. Over the years, the legislature has opted to include select few jurisdictions' correctional officers into the presumption. It is without question that correctional officers and deputies face the same stress and occupational hazards as their law enforcement brethren. The fact is, those occupational hazards simply do not change when you cross county lines. Correctional deputies in Carroll County must deal with a litany of stressors: constant high stress, physical demands, irregular shifts, emotional burden, limited opportunities for decompression, the list goes on. A study conducted by Southern Illinois University found that chronic high stress, long difficult shifts, and elevated anxiety amongst corrections officers lead to higher rates of PTSD than military veterans, suicide rates twice as high as other professions combined, and increased risk of substance abuse. These stressors certainly provide for increased cardiovascular risk, just like they do for police and firefighters. Particularly eye-opening is that the average life expectancy of a corrections officer in the U.S. is 59 years old versus 75 for the overall population. In the last 10 years, the Carroll County Sheriff's Office has lost 2 correctional deputies to sudden heart attacks. Both deputies who passed held long careers for the Carroll County Detention Center. These fine men were no doubt victims of the toll that the career can take on the body. For these reasons, I would ask that the committee issue a favorable report for Senate Bill 0449.
Thank you for your testimony, and thank you for your service.
Thank you.
I don't see any questions, so that ends the hearing on 449. Senator, we're going to go back to an earlier bill and then come back to you, okay? Thank you. So we have Gregory is here on Senate Bill 898, Senator McCrae's bill. So Gregory, do you want to come up? And we'll see if you have a panel. Let's see. We have Brittany Rader, Brett Cohen, and Obi Chinamere. And no one's unfavorable. We have all favorables. So you can begin when you're ready, Gregory.
Good afternoon, Chair and members of the committee. For the record, my name is Gregory Ball. I'm an intern working for Senator McCrae, and I'm here to speak on his behalf regarding Senate Bill 898, legislation that expands access to essential behavioral health services for individuals with autism spectrum disorders by requiring the Maryland Medical Assistance Program to reimburse applied behavior analysis services provided by registered behavior technicians. Applied behavior analysis is a widely recognized evidence-based therapy used to support individuals with autism spectrum disorder in developing communication, social, and behavioral skills that are critical to daily functioning and long-term independence. Senate Bill 898 ensures that services delivered by registered behavior technicians who work under the supervision of licensed psychologists or board-certified behavior analysts are eligible for reimbursement through Maryland's Medicaid program. By recognizing the role of registered behavior technicians in delivering ABA services, this legislation helps expand the behavioral health workforce and improves access to care for families who rely on the Maryland Medical Assistance Program. The bill also provides flexibility by allowing technicians to obtain required professional certification within a reasonable time frame after beginning service delivery, helping reduce barriers to entry while maintaining quality standards. We ask for a favorable response.
Thank you, Gregory. Go ahead.
Hi, good afternoon. Thank you so much for the opportunity to speak today. My name is Brittany Rader. I'm a board-certified behavior analyst, and our organization provides in-home behavior therapy to children diagnosed with autism across the state of Maryland, and we currently serve approximately 850 children within the state. I'm here today to ask for a simple change, which is extending the window for technicians to pass the RBT exam from 90 days to 150 days. This proposal does not change the certification requirement, nor does it lower the standards. Every technician has to still take the same exam and meet the same supervision requirements. What it does is give hardworking technicians a realistic amount of time to complete that requirement while continuing to support the families they serve. In behavior therapy, consistency matters. These children build trust and make progress in relationships with their technicians. But under the current 90-day limit, each technician that hasn't passed the exam has to be taken off of their case. And that then urges providers to rotate staff on that same child, which then results in that same child receiving multiple technicians within a short period of time. Extending the window to 150 days allows one technician to stay with the same child longer. It's also really important to understand what the exam is and what it is not. The RBT exam verifies a base level of competency. It's not where technicians develop their clinical skill. The development happens through hands-on training and supervision by licensed clinicians, which is already required, and that would not change throughout this duration of the process. It simply allows technicians more time to schedule and pass the test. Another important issue is language access. The RBT exam is not offered in Spanish right now, yet many of the families we serve are Spanish-speaking families. So when you have a Spanish-speaking staff on the case and they are forced to comply with the 90-day requirement, ultimately the families that are impacted the most are Spanish-speaking families. This simply gives technicians a fair chance to succeed while continuing to serve families who benefit from their care. Thank you for your time and consideration.
Good afternoon, Chair Beidel and members of the Senate Finance Committee. My name is Brett Cohen, and I'm here representing Behavioral Framework. We are a Rockville, Maryland-based autism therapy provider. We serve hundreds of kids across Maryland, and I'm here in support of this bill. We face a shortage of behavioral technicians, and families right now often have to wait many months to access services for their children who require autism therapy. This bill addresses a policy that right now is making that shortage worse, and we urgently wish for a favorable report to extend the time frame for behavioral technicians to be able to become registered behavior technicians. It's important to note what they actually have to accomplish in those 90 days. It includes a 40-hour training, supervised assessments, a proctored exam that is offered with limited availability and limited sites. As Brittany mentioned, for these technicians who maybe are Spanish speaking, the exam proves an additional challenge because it is only offered in English. Many of these are outside the technician's control, but they often bear the full consequences. And the result is not just an administrative issue, it often impacts therapy because autism therapy depends on routine and consistency, and every time that a child has to have a new technician begin to provide the therapy, it can essentially take a step backwards for a lot of months of hard-won progress for that child. Also worth noting that the state of Maryland requires an RBT certification. Some neighboring states like Virginia and Pennsylvania do not have such a requirement in place. Finally, and most urgently, recently, the Maryland Department of Health announced that ePrep, which is an online enrollment portal that RBTs as well as all providers need to enroll in to get to be able to serve Medicaid clients, is going to be taken offline beginning in July for several months and will not be launched again until October. we will not have the ability to enroll new technicians, and that will further exacerbate the shortage, making this bill even more urgent. Thank you. I urge a favorable report.
Thank you. Obi?
Good afternoon, Madam Chair, members of the committee. Obi Chinnemer on behalf of Behavioral Framework. I just want to take a quick second to essentially address something that was noted in the physical note. MDH put out an analysis that said in the 1,200 people that they looked at, about 28% of people finished in the 90-day period, and consequently, that 90-day period they used to also say that the people who were doing that care essentially weren't getting the standard of care that was needed. I wanted to push back because I think that's a chicken or egg argument. The idea that somebody didn't finish in 90 days would therefore make them not qualified to do that service, I think doesn't make sense. It's almost like going to law school. If you took people who are in part-time law school, as there are a lot of part-time people who have second jobs and other responsibilities, and gave them the responsibility of going to law school full-time, they may not pass. That doesn't mean they can't be lawyers. It doesn't mean that they can't practice the application of law. It simply means that the time frame given to them does not match. So all we're simply asking for is, if you were to add it to 150 days, we don't know what the construct would be. We don't know what the numbers would be. It could be higher. So all we want to say is that we respect MDH's take on this, but at the same time, we think that the numbers that they're using kind of conflates success within a window. So I would say in that 90-day period, there are people who probably needed 30 more days to actually, pass this exam and finish that didn't get it. And in their statistics, they're counting them as somebody who may be an additional burden. So with that, we urge a favorable report. Thank you.
Thank you. I have a question. When do you think they might have a test in Spanish?
I don't think it's coming anytime soon. That would be required by the Behavior Analyst Certification Board, and they've tried to push that for years, and it's only offered in English.
Yeah. So what happens now if someone is a Spanish-speaking person? Does someone sit with them through the test?
No, those accommodations are not offered currently. I can only speak what we do as an organization, which is obtain Spanish-speaking staff on hand and work with them directly to understand the terminology and how to interpret the questions. But that doesn't exist everywhere.
That's sad, especially when you have a lot of Spanish-speaking clients.
Yep.
Thank you for your testimony. I don't see any other questions. Thank you very much for the bill.
Thank you.
That ends the hearing on Senate Bill 898, and we're going to go back to Senator Reedy. So, Senator Reedy, you're going to do Senate Bill 839, Medical Assistance Program Drug Dispensing, and you have Michael Patty, Caitlin McDonough, and Brian Hose. Favorable.
Thank you, Madam Chair. It's great to be before the committee again, and as the panel comes up, I usually have at least a couple good ideas a day, and I've got two of them in the committee today. So two good bills. So if you don't believe in your own ideas, it's gonna be tough to. Thank you, Madam Chair. I know it's been we're in that crunch time of session, so we're all a little tired, but I think these are important issues we're discussing today, and this is another really important issue as we talk about drug costs, drug dispensing. This is bipartisan legislation, very straightforward, that simply mandates that the Maryland Department of Health conduct an in-state dispensing survey and regularly conduct those surveys every 3 years going forward. Additionally, to ensure that the actual fee accurately reflects the underlying data, the fee-for-service dispensing fee must be updated to reflect the most recent survey within 6 months. Maryland has not conducted a survey to determine the Medicaid fee-for-service dispensing fee since 2018, and it was implemented by regulation in 2021. Now, I don't know about you. We had a few changes in the health system since 2018. We had a little something happened in 2020, and that changed a lot of things about health care, at least for a little while. And I think it's time. I think 2018, it's time for us to do a new dispensing fee. Maryland's current fee-for-service dispensing fee has not kept pace with inflation, labor costs, technology requirements, or regulatory obligations that are placed on our pharmacies. And this impacts our small pharmacies and independent pharmacies most of all, which is a group that's close to my heart, but it impacts all pharmacies. This is especially true since the most recent survey, as I said, was conducted pre-COVID. Independent cost of dispensing studies consistently show The true cost of dispensing a prescription is a lot higher, significantly higher than Maryland's current reimbursement structure. Maryland pharmacists really have been asking for, and they need an accurate reflection of the actual costs of the fee, FFS dispensing fee, to help ensure that they're getting accurate reimbursements. Data is also essential for us as policymakers as we discuss in both the legislative branch and also at the department level and the executive level. As we discuss effective reimbursement, as we discuss the overall cost of drugs to the consumer as well. All of these are important things. This bill does not alter current law in any way that ties MCO reimbursement to the fee-for-service fee. Other bills in recent years have tried that a little bit, and I think there's a recognition that we need to not take that path here, but we do need to get the data that comes with updated surveys. Colorado has a similar mandate for an annual survey, but we have suggested in this bill, and I really appreciate Delegate Carlson as the sponsor in the House, working together with her. As I said, it's bipartisan, nonpartisan legislation. We believe every 3 years accomplishes the goal with less administrative burden to the department. The bill is consistent with other Maryland policies that ensure our workforce, including essential health workers, that their compensation accurately reflects real-world costs, and that's what we're trying to do for our pharmacies. So I would respectfully request a favorable report on Senate Bill 839. Have a panel here with me, and then we're happy to answer any questions.
Yeah. Thank you, Madam Chairwoman, members of the committee. I'm Brian Hose, representing Epic Pharmacies, a group of independent pharmacies in the state of Maryland, as well as my own pharmacy, Sharpsburg Pharmacy. Senator Riddy got into this pretty well already, but we have seen that since this program was first started in 2018, at least 2 surveys have been conducted, one prior to that initiation and then again in 2018. Pharmacies were under the assumption that this would be a regularly updated number. What we've seen in practice is that it has not been updated by the department continuously. He also pointed out that during COVID, there were a lot of supply chain issues. Things changed drastically. Sorry about that. Recovering from a cold as well, so it's not great, I'm sure. But during COVID, we saw significant supply chain issues. Maryland has raised the minimum wage significantly between the time of these surveys. We see increased overhead costs for inventory, packaging, rents, paper goods, pharmacy supplies, you name it, everything that goes all the way down the list to the wages of our employees that we keep working for us here in the state of Maryland. So we would encourage that this be done every 3 years. We would also encourage the 6-month implementation timeframe, because what we saw with the 2018 survey is that the department waited years to implement the new amount. So that's where that 6-month recommendation comes from, and we would encourage a favorable report.
Good afternoon, Madam Chair, members of the committee. Caitlin McDonough on behalf of Epic Pharmacies here in support of Senate Bill 839. I think Brian and Senator Reedy covered summarizing the bill very well. The only thing I would note for the committee is the House committee will be taking this bill up in subcommittee tomorrow, and in talking with the House sponsor, they do not anticipate any changes to the bill. So we look forward to working with them and with this committee and urge a favorable report. Thank you so much.
And Michael Patty here today on behalf of the independent pharmacy owners of Maryland in support of Senate Bill 839. And I just want to say, Senator Reedy, this is a great idea. That's why we're up here in support of the bill. I did just want to highlight real quickly the 6-month time frame. Obviously, many of you are familiar with the previous role I had. I promulgated a number of regulations through an agency. 6 months is absolutely doable. And just to kind of frame what the regulation that we're talking about, it's one number. It's just updating that number. It's not lines and lines of regulations that need to be vetted with a number of stakeholders. It's just taking the survey results, doing a calculation, and putting that number in reg and promulgating that regulation to the Maryland Register. So with that, we just ask for a favorable report. Thank you.
Senator Kramer.
Thank you, Madam Chair. So, Senator Reedy, I just want to make sure I have this right. The bill before us, looking at the fiscal note, provides that Medicaid expenditures increase and 50% are general funds, 50% are federal funds. Then it continues, to the extent the survey necessitates an increase in the professional dispensing fee, Medicaid expenditures increased by an additional indeterminate but significant amount. Am I correct that Senator Reedy has introduced a bill that increases fees and costs? I just want to make sure I have this correct.
I would say they're already been increased on the people providing the service, so we're just trying to be sure that our private sector job creators are compensated accurately.
And once again, it creates additional costs and fees to the taxpayers, to some degree of this state, should this bill pass. I just want to make sure I fully understand that.
The fiscal note does say it's going to cost the state $40,500 twice to do this survey over the next 4 years, because you'll do it twice in 4 years. Could see some Medicaid expenditures increase. It is true, I guess so. I just want to be sure we're providing for our folks on both ends. It's another reason why we should examine Medicaid eligibility issues, but that's a separate discussion for a separate time.
So when this bill comes to the floor, we're not going to hear the minority or the majority leader get up and start raising concerns about increases in fees and costs, and after there were promises there'd be no increases in fees and costs. We don't have to worry about that?
Well, it's not a fee or a tax. It is a cost associated with providing care for those who need it and making sure that pharmacies can afford to provide that care. So yes, I mean,
the money has to come from somewhere. It may not, in your definition, be a fee or a tax, but somebody's paying for it, and I believe it would be the taxpayers.
Yeah, I'd be happy to work with you on identifying some savings to make sure we offset those costs. I bet we could find them.
Okay. I just wanted to make sure I understood what I was reading. So thank you, Madam Chair.
Thank you, Senator. I don't see any other questions for this panel. Thank you all very much for your testimony. Next, we have Fitzgerald Mofor and Aaliyah Horton, I think.
Good afternoon, members of the committee. My name is Aaliyah Horton. I'm the executive director of the Maryland Pharmacists Association. We are a professional society, and this bill, the panel that was here before, really represents the actual pharmacies and community pharmacies in your districts. But the bills that are passed that impact pharmacies impact pharmacists and the work that they do. So this bill ensures a consistent schedule for the conduct of the pharmacy cost of dispensing survey and timely implementation of the survey results. The bill ensures the fee-for-service professional dispensing fees reflect real pharmacy costs instead of relying on outdated estimates. Pharmacists ensure medications are dispensed accurately, counsel patients, monitor for safety issues, conduct drug utilization reviews, and other services that require investments in product, in packaging, pharmacist and technician labor, technology, compliance, and other patient safety processes. The fee-for-service program is actually a small portion of the pharmacy services, but it is one area where we can ensure that professional dispensing fees reflect the true cost of providing services and do not add to the financial strain already caused by the reimbursement practices in the managed care program. As such, we urge a favorable report of SB 839. Thank you.
Thank you for your testimony. You have any questions, Senator Kramer? All right, thank you, Elaine.
We hope it goes up.
That ends the hearing on Senate Bill 839. Next, Senator Hershey, we're going to do Senate Bill 832, Nonprofit Hospitals Community Benefits. You have Peter Pitts is virtual, Jamie Gregory, and Bridge DeMay.
Does this bill increase any fees?
No, sir. No, Senator, it does not. Is Bridge here? Have we seen? Thank you, Madam Chair, Mr. Chairman, members of the committee. For the record, Senator Steve Hershey to present Senate Bill 832, Nonprofit Hospitals Community Benefits. The purpose of this legislation is to provide additional clarity and transparency on the exact sum and beneficiaries of the community benefits that Maryland's nonprofit hospitals are providing in communities and around the state. This legislation, alongside a package of amendments, are the product of extensive conversations between the stakeholders, including the Comptroller's Office, the HSCRC, the Maryland Hospital Association, SEIU 1199, and others. The amendments address the Comptroller's comments and have significantly addressed the comments received by the HSCRC. While this does not address all the concerns, I believe this and the continued conversations we're having with the Health Committee in the House are getting us very close. I also want to acknowledge the members of this committee and stakeholders around Maryland who have done significant work on improving the reporting on hospital community benefits in the recent years. In many ways, Maryland is a leader. However, I believe there is significant room for improvement. I'm introducing this bill for a few simple reasons: transparency, accessibility, and affordability. Although the HSCRC does great work collecting and reporting hospital community benefits, there are still gaps and a need for additional clarity. Hospitals are doing great things, but the lack of oversight and inability to estimate the value of their tax exemptions make it impossible for the public to reasonably compare the benefits provided against the value of the exemptions received. This is truly the purpose of this bill, to create an added level of transparency. Additionally, as mandated by federal law, hospitals produce community health needs assessments every 3 years and provide them to the HSCRC. These reports are designed to identify community health needs and develop strategies to address them. However, according to the FY24 HSCRC report, only 42.5% of the net community benefits are spent on community health plans that they are legally required to develop with community input. Lastly, there's a significant ambiguity on what the CHNA spend actually goes to. As I mentioned before, I'm extremely grateful to the HSCRC and the individual hospitals for their existing reporting work. However, it is imperative that we know exactly where these benefits are going, exactly how they are helping our communities, and exactly how much each hospital should be spending compared with the value of their tax exemption. Finally, the Comptroller has advised the House sponsor that with these amendments, the Comptroller's Office can implement this legislation with existing resources. I look forward to having additional dialogue with this committee on the bill, as well as continuing the conversations with all advocates. With that, I respectfully request a favorable report on Senate Bill 832. Thank you, Mr. Vice Chair.
Vice Chair Hayes, members of the committee, my name is Jamie Gregory. I'm here representing Consumer Action for a Strong Economy. We thank Senator Hershey for introducing this bill here and Delegate Dana Jones on the House side. As mentioned, nonprofit hospitals enjoy significant public benefits. In return, they are expected to deliver charity care and community benefits that justify those privileges. According to the Loan Institute, a healthcare think tank, 18% of Maryland's nonprofit hospitals do not give back as much as they receive. In Maryland, nonprofit hospitals receive approximately $587 million annually in tax benefits, which include local property tax exemptions, state sales tax exemptions, state income tax exemptions, federal income tax benefits, and access to tax-exempt bond financing. As Senator Hershey mentioned, in 2020, this committee passed reporting, but more can be done. Senate Bill 832 would establish measurable performance thresholds for state tax exemption. Nonprofit hospitals would be required to provide community benefit equal to either 100% of the value of tax benefits received or 5% of net patient revenue. The bill will strengthen the nonprofit hospital social contract by aligning public subsidy with public return. And at this point, I'd like to introduce Peter Pitts, who's virtual president of the Center for Medicine in the Public Interest and is the former Associate Commissioner of the U.S. Food and Drug Administration. Ooh, you're on mute, Peter.
Yep. Yeah, okay.
Only my wife had that button.
Madam Vice Chair, members of the committee, thank you very much for allowing me to testify and to do so virtually on this panel. Though hospitals in Maryland receive millions of taxpayer-funded subsidies and donations, many fail to meet expectations for providing affordable care and meaningful community benefits. These hospitals often function like for-profit entities despite their tax-exempt status and public funding sources. In Maryland, hospitals increasingly avoid Medicaid and uninsured patients due to lower reimbursement rates, focusing instead on services favored by private insurers, leading to inequities in care. Maryland's hospitals, like many nationwide, face criticism for prioritizing profits, aggressively suing poor patients, and failing to provide community benefits commensurate with their tax exemptions. These issues highlight the need for increased oversight and accountability in Maryland's hospital sector. Some recommendations include: 1, establish clear standards, define and enforce clear criteria for what constitutes adequate charity care and community benefits. 2, establish charity care minimums. Tie tax exemptions to specific charity care thresholds that reflect hospital capacity and community need. 3, enhance transparency. Require detailed public reporting on financial practices, including the allocation of community benefits and lobbying expenditures in zip code level detail. And finally, 4, conduct regular audits. Mandate third-party audits to ensure compliance with IRS and state-level nonprofit regulations. It's not that much to ask. Thank you very much.
Good afternoon, Chair, members of the committee. For the record, my name is Marceline White, Executive Director of Economic Action Maryland Fund, and we're here in strong support of Senate Bill 832 as amended. As noted, this really builds on the strong work that this committee has done over the past 5 years, and it's really the next step in increasing transparency. As you know, all Maryland hospitals are nonprofits, which means that the tax breaks in return for the tax breaks, they have to provide community benefits. Currently, there are 3 major issues with hospital community benefits. First, hospitals are not reporting the value of their tax exemptions, so it's difficult for the public to determine whether the charitable work is commensurate. Next, reporting does not clearly show how much of a hospital's community benefits spending directly supports initiatives that you all care about, which is to improve population health outcomes, which you've worked on for a number of years. Lastly, too many hospitals are not adequately engaging communities in the development of the initiatives and the implementation of these community benefit plans. And so, for example, today there is an $82 million deficit between what Maryland nonprofit hospitals receive in tax breaks and what they return to communities. That $82 million represents funds communities need and could be used to expand charity care or address social determinants of health. SB 832 simply says hospital community benefits should at least equal their tax breaks. The bill increases government transparency, it builds public trust between communities and hospitals, and ensures hospitals are meeting their legal requirements to provide these benefits. Hospitals should be able to meet these obligations because it has been a condition of their nonprofit status for decades, so they should have had plenty of time to be able to report effectively. For these reasons, we support SB 832 and urge a favorable report. Thank you.
Greetings, I'm Bridge Dumais, Political Coordinator with 1199 SEIU, United Healthcare Workers East, the largest healthcare workers union in the nation. We urge a favorable report on SB 832 with a friendly amendment. The HSCRC found that Maryland hospitals only spent on average 37% of community benefits dollars on priorities identified by the Community Health Needs Assessment they are legally required to conduct and implement in exchange for their tax-exempt status. Some hospitals were even found to have spent 0% on community health needs that were identified by this report. You heard that right. I said 0%. Several more hospitals were found to have spent less than 10%. Our proposed amendment to this bill would require that at least 80% of a hospital's community benefits spending be directed towards priorities identified through the Community Health Needs Assessment to ensure that initiatives actually meet community needs. You'll probably hear from highly paid hospital executives, lobbyists, and public relations professionals that, oh, we don't need this bill, just trust us. But let's not forget that Maryland hospitals also claim to provide free health care to low-income patients, and were found to have charged those very same patients $60 million per year for almost a decade. The General Assembly passed legislation to refund those patients. Hospitals also claimed they were notifying patients that they may be eligible for charity care, but the General Assembly had to step in yet again to pass legislation strengthening these notification requirements because patients were not being properly informed. Hospitals have also claimed there's no staffing shortage, but workers across the state are sounding the alarm on dangerous understaffing. That's why the House has passed the Safe Staffing Act for 2 years in a row to address this crisis. So, as you can see, just trust us is not good enough. SB 832 says prove it. Hospital executives should have nothing to fear with this bill if they're truly spending what they claim on community benefits that meet community health needs. I urge a favorable report with an amendment. Thank you.
Thank you so very much, and thank you for sponsoring this legislation, since Senator Hershey, very sensible piece of legislation. Senator Washington.
Mr. Chairman, you took the words right out of my mouth. Sounds sensible. Sounds like something we should do. A little bit more transparency. You know, being able to understand what the hospitals do. You know, I seen where they said the Hospitals Association and are complaining a lot about how the community benefit under loan hospital index. They're saying that you guys are wrong. Can you tell me why they are right and why you're right and they're wrong with the LON? Is LOWN? I'm not sure if I'm saying that right. The LON and hospital index. Can you explain that a little bit?
This is the Loan Institute measures whether or not hospitals give appropriate community benefits back to the community. And it's curious that they should quote that particular study, because what that study shows is actually how poorly Maryland hospitals do relative to what they should be doing on community benefits. You know, pointing to specific data points out of context is a classic management technique, as you know, and that's exactly what they're doing. They're trying to take your eye off the prize by collectively.
It says here that in fact 10 of the 11 hospitals received an A rating on community benefits from LON, according to their most recent study. Is that wrong?
Well, you need to go into what the Loan Institute report actually goes directly to the tax returns of these institutions, and it shows you the high rate of compensation of many of their executives and how their overall revenue reflects on community benefits. There are lots of ways to report revenue. In my opinion, the best way is to go directly to their IRS forms, which are public information.
You know, I brought this up to some of the folks on the panel when we met, and you know, before Luminous took over Doctors Hospital in my district, I always wondered what in the world are they doing for our communities? What are they doing? I've been in the office for multiple years. I haven't seen them around. They don't come to community events. They rarely have inviting events on their campus at all, and they don't have a real connection with the community. Under Luminous has gotten a little bit better, but I think it should be a lot more. And I appreciate the impetus for this bill and the reasons why you guys are proposing it, because we do need a little bit more transparency and we want to see more community engagement out of these hospitals too. And that's what our community wants. So I really do appreciate this bill, and thank you.
Thank you, Senator.
Senator, go.
So, Jamie, I was just looking at the written testimony that was provided by MHA, and it says, you know, the federal law, that there's already a lot of reporting they're supposed to do, right? Federal law requires them to complete a Schedule 8 of the IRS Form 990. The Maryland law requires hospitals already to report the hospital's mission statement, a list of the hospital's activities to address identified community health needs, costs of each community benefit activity, how each of the listed activities address the health needs of the hospital's community, efforts to evaluate the effectiveness of each community benefit activity, and it looks like there are about 6 other bullet points below that. So it says HSCRC requires hospitals to report on community health services, health professions, education, research, financial contributions to other organizations, and there are another 6 or so more, I don't know, or a handful of other bullet points below that. So I guess what I'm trying to understand, what more information do you want that is not already being reported?
Very simply, how are they meeting those needs? How are the individual hospitals meeting those needs in their individual communities? I think is the primary.
I mean, that's one of the bullet points right on here. What Maryland law already requires. Is it just that you don't find that the reports are adequate and that
Correct.
That's what it is.
If
So
you
why?
go- if you go
I
to
guess
the-
what I don't understand is there's existing law that already requires them to do it, but you don't find the reports adequate. So how are we changing the law then?
The narrative in, so when you go to the commission website, right, you can pull up the community health needs, and then there's a narrative. And the narrative discusses the needs of the community, but doesn't address how are the individual hospitals addressing those needs.
Okay.
And the whole point of this bill is more transparency.
Okay, I mean, because it says a list of they're supposed to report on a list of the hospital activities to address identified community health needs. So, I mean, it sounds to me like there might be an enforcement issue, not so much an issue of requiring them to do more, since they're already required to do all this, right?
I think it's not, I was just going to say, I think it's not just the reporting of what's being provided, but it's
Senator,
kind of,
do you want the microphone right? Maybe Marceline can move it for you.
I grabbed this one. I'll just be real quick, and I'd want to hear Marceline's response as well. But I think part of what you're looking at is it's not just the level of service, but how it equates to the value of the tax exemption. That seems to be the big part. So you can make a long list of here are the things that we're doing, but if they can't adequately provide what the tax exemption they're getting, it's hard to then create a value for the services that are being provided.
Yeah, I understand that, but it looks here, like to me, that Maryland law already requires them to provide great substantiation as to the tax benefits that they are getting. So, I mean, what I'm hearing, what sounds to me is that there's just frustration with the adequacy of the reports that are being provided. But with that, Mr. Vice Chair, I'll let it go.
Sorry.
Thank you.
No problem. Thank you, Senator. Senator Kramer.
Thank you, Mr. Chair. Just a quick observation about today. Moments ago, I heard a bill sponsored by the minority whip that increased costs and fees. And now sitting before me is the minority leader with my good friend, Bridge Dumais, SEIU 1199. I fear that very soon cats will be laying with dogs. And life as we know it will be turned upside down. But I do just want to comment that I appreciate the last bill. I appreciate this bill. But, Senator, I will bring to your attention that there's a fiscal note on this bill that indicates that costs may increase expenditures by as much as $325,000 next year. And that general fund, that special fund, and general fund expenditures increase on average by $80,000 a year should this bill pass. So once again, I'm just, I support the concept and what it is you all are seeking. I just am somewhat taken aback.
And I appreciate you noticing that and appreciate that you recognize that many of us can get together when it's about accountability and transparency. At the same time, I think with respect to the fiscal note, as I mentioned in my testimony, with the amendments, the comptroller has stated that she can take care of the bill with existing resources. So I think that satisfies the fiscal note.
Thank you for sharing that.
Well,
Thank you, Mr. Chair.
Senator, also relative to that point, one of the
I'm sorry. There's only one answer per person. Give me a second. Senator Lamb.
Thank you, Vice Chair. I was going to ask if Marceline can just respond. I know you wanted to respond earlier to the value question. Can you present a response to that?
Yeah, absolutely. Thank you so much. I think in addition to what the senator said about the value of the tax exemptions, which makes it hard to compare and see how much, if they're getting X tax break, are they providing the commensurate benefits? I think the other piece of it is how engaged and involved the community is in developing the community benefits plans and how collaborative it is. As Senator Washington mentioned, that's something that patients want and people in communities want to make sure that the community benefits plans that are developed actually reflect the needs of that community. And that is also not in any of the reporting that is required so far, and is a way that we would increase transparency and make sure that this was actually happening, and that our communities are able to engage and make sure that the plans meet the needs of the surrounding environment and the footprint.
Yeah, I mean, and appreciate this bill. I mean, this has been an issue that, I've been watching for the last 12 years. I've been in the General Assembly with just a lot of concern that, from a public health standpoint, our hospitals are oftentimes anchors in our community. They have a lot of resources. They have probably some of our best resourced. I know they're under strain, but they're probably some of the best resourced in our local jurisdictions. I know we have a bill coming up dealing with the Public Health Commission, and we'll be hearing from MHO and our local health officers how they're struggling and oftentimes are looking to our hospitals to be able to have that support. I think when it comes to value, I think that is an important thing to keep in mind. The reason I've been leery of this subject over the last 12 years is because from a public health standpoint, you could have a hospital go out and say, look, I've got to spend another $10 million in community benefit dollars. And they could go out and spend that on, 1,000 health fairs, another 10 million stress balls, and that could all fall under the health education part of this current law that's in place. I don't think 10 million stress balls, another 1,000 health fairs is what we had in mind in real community benefit, but it would still fall under this category of health education. Yes, we're educating the public because there are 10 million stress balls with our logo on it out there, right? That's not the intention of community benefit dollars when it was first conceived. Yep. And so, the reason I appreciate this is because I think this is really trying to drive at public health and trying to do what all of us from the public health space want to be done to help bridge the gap between what we see in the hospital and clinical medicine and being able to provide the supports out in the community so that people don't have to go to the hospital, right? That is the whole intention of our global budget system that we have here. And even, one could make an argument that with the Population Health Improvement Fund that's been created by the HSCRC, it's another way of trying to drive some of those dollars out of hospitals to get into the community so that you can prevent people from having to end up in the hospital. Yep. And so, for that reason, I think, the intention is very positive here. I did have a question about, in the existing statute, it says a community benefit may include charity care. So just trying to understand why you created a new category here of government-sponsored indigent care, which looks like, based on how you're defining it, is really Medicaid.
The amendments took
Medicaid?
that out. Great point. The amendments took that out.
Oh, you took that out?
Yes.
Okay,
Yep,
all right, so that addresses
We took
that.
out charity care and we took out government-sponsored indigent care. Both of them are out because they had to be defined in here. And then we decided with our conversations, as I mentioned earlier, to remove those with the amendments.
Well, charity care is in the existing statute. You're leaving that in the existing statute, right? On page 2 of the bill, community benefit may include.
Yeah, maybe it was just because it was duplicative already in there, but certainly government-sponsored indigent care was taken out. So.
Okay. Yeah, I mean, I think looking at, how some of these reports are filed, I just, I'm not sure that it provides and demonstrates the level of value that we need to see out of the spending that is supposed to be taking place because these institutions have a tax or a nonprofit status, right? And so, I think the intention here was to do more. And, the way I'm looking at this bill is that it intends to do a little bit more than that. Removing you said that removing the HSCRC or that provision of it should remove the cost of it, right? So if you could just, what is the enforcement mechanism here then on that?
From the amendments, and this is off from memory, is there would be a process if a hospital fell short that they could work to cure and resolve that. And then I believe there'd be a process where the Attorney General would work with the comptroller, from my understanding, about what the next steps were. Because the goal is to have everyone remain a nonprofit hospital, but to make sure that they are meeting the obligations.
Okay, so that should address the cost issue, because a lot of this cost in the fiscal note is really referencing back to the HSCRC. Then.
Exactly.
Okay. All right, thank you.
Questions? Doesn't appear. And it ends this panel. Thank you very much.
I think everybody had a question.
We have
Thank you.
2 more people favorable, Ashlyn Randolph and from the League of Life and Health Insurers, and Marceline White. Are they both, were you up there?
I was up there.
Okay, so Ashlyn's coming up all by herself. But she's comfortable in this committee, so she'll do just fine. Nice to see you, Ashlyn.
Hello. Good afternoon, Chair Beidel, Vice Chair Hayes, and members of the committee. My name is Ashlyn Randolph, and I'm here on behalf of the League of Life and Health Insurers in Maryland in support of Senate Bill 832. The concept behind this bill is straightforward. Every hospital in Maryland operates as a nonprofit. In exchange for that status and the tax benefits that come with it, hospitals are expected to invest in their communities. Maryland has always given hospitals flexibility in how they do that, whether through behavioral health services, housing programs, or other initiatives that fit their mission and the needs of the people they serve. That flexibility makes sense. What has been lacking is sufficient oversight to ensure those dollars are actually spent as intended and not redirected. Senate Bill 832 addresses that gap. It establishes a clear spending floor, requires itemized and transparent reporting, and creates an accountability mechanism for hospitals that fall short. Maryland's all-payer model works because every participant, hospitals and insurers alike, are held to a defined standard. Insurers are held to rigorous standards under that model, and it's only reasonable that hospitals be held to theirs as well. When community benefit dollars are spent for their intended purposes, the result is healthier communities, and healthier communities mean better health outcomes for every insured person in this state. The standard already exists. This bill just ensures that it is enforced. We urge a favorable report on SB 832, and I thank the committee for its time.
Thank you, Ashlyn. I don't see any questions. You're getting off easy.
Thank you.
It's your first time here in the committee, isn't it?
Yes, it is. It's very surreal to be on this side of the table.
Thank you for being here.
Thank you.
And we have 1 unfavorable, Jane Cranky from the Maryland Hospital Association.
Good afternoon. Good afternoon, Chair Beidel, Vice Chair Hayes, and members of the Finance Committee. My name is Jane Krinke. I'm here on behalf of the Maryland Hospital Association in respectful opposition of Senate Bill 832. We appreciate Senator Hershey's intent with this legislation and do agree that hospitals should provide publicly accessible reports about their community benefits, and we think that that goal is already accomplished. You can look at individual reports online as well as the aggregate reports, and they all follow the template provided by the HSCRC. Maryland is one of 11 states that have tied the community health needs assessment to the community benefit regulations. So there's that inherent tie. We don't think this bill brings any more transparency or value to the reporting process. I do want to point you to the HSCRC's testimony, which raises some concerns, including about determining the tax exemption value. HSCRC conducted a tax benefit assessment back in 2020, I believe, to determine if they should require hospitals to provide a specific estimate of the value of their tax-exempt status. And they found it would be possible, but be very time-consuming and complex. In addition to the reporting requirements, the timeline in the reporting requirements conflict with the newly revised regulations and reduce the flexibility. So back in 2020, legislation passed that created a stakeholder work group process to develop the process that currently exists. And so this bill has not gone through that stakeholder development process, and so there are conflicts. Additionally, national studies have compared the value of the tax benefits that hospitals receive against their community benefit investment, and Maryland has been ranked consistently in the top in the nation. So we think that that is important. Maryland is a leader in this space. We are transparent. And you can find a lot of the list of community benefits that hospitals provide, like Senator Lamb mentioned, they range from community health education to free clinics to vaccinations, health screenings, as well as addressing the social determinants of health. And for these reasons, I just asked for an unfavorable report. Happy to answer any questions.
Jane, any questions for Jane? You're frowning, Senator Hershey. There are no questions, Jane. Thank you. That ends the hearing on Senate Bill 832. Is Senator Charles here?
Yes.
Okay. So Aiden Sotili, Aiden, are you here? You're going to present Senate Bill 549. You have Dolores Millhouse and Teresa Smith with you. Thank you.
Good afternoon, Chair Beidle, Vice Chair Hayes, and members of the Finance Committee. For the record, I am Aiden Sotili, Policy Outreach Coordinator for Senator Nick Charles, representing District 25 in Prince George's County. I'm here today to present Senate Bill 549, the HER Continuity of Care Act, where HER stands for Healing, Equity, and Representation. So under current law, when an individual is admitted to a mental health facility, the facility must ask whether the patient consents to a family member or other individual participating in discussions about their treatment plan. That right exists in statute, and if consent is provided, the individual may be informed of and participate in treatment team meetings related to the patient's care. However, the statute does not require that this right be clearly explained or presented in a way that ensures patients fully understand it during the admission process. In practice, the consent question is often embedded within broader intake paperwork that patients must complete at the very moment they may be experiencing significant financial distress or psychiatric distress. This bill addresses that gap at the very beginning of the treatment process. When individuals are admitted to a facility during a mental health crisis, they are often not in the best position to navigate complex paperwork or fully process the rights being presented to them. Current law technically allows patients to involve family members or other trusted individuals in treatment planning. However, that option can easily be overlooked during an already overwhelming admission process. Senate Bill 549 requires facilities to clearly inform patients of this right, both verbally and through a separate plain language form, so individuals can make a meaningful decision about whether they want someone they trust involved in discussions about their care. This bill also ensures that when individuals have already executed documents such as a mental health advance directive, a healthcare power of attorney, or a supported decision-making agreement, facilities recognize those documents as a request for that trusted individual to participate in treatment planning. Importantly, patient autonomy remains fully intact. Participation only occurs with the patient's consent, and providers may still limit involvement if there is clear evidence that participation would harm the patient. At its core, this legislation simply ensures that individuals in a mental health crisis are clearly informed of their rights and that their documented choices about who may assist them in navigating care are respected. We have taken note of the opposition and remain committed to working collaboratively with stakeholders to refine and amend the bill as needed to ensure it is implemented in a practical and effective manner. For these reasons, I respectfully ask for a favorable report on Senate Bill 549. Thank you.
Good afternoon, Chair Beidle and members of the Senate Finance Committee. I'm here to urge a favorable report on Senate Bill 549, the HER Continuity of Care Act. I speak to you today not just as an advocate and mother, but as a professional with a background in patient safety, policy development, and industrial engineering. I know the systematic breakdown what the systematic breakdown looks like. And during my own child's mental health crisis, I watched firsthand as the system failed basic safety protocols and continuity of care standards. Even with legally executed documents in hand, I was denied access to my child's treatment process. Instead, a basic release of information form was offered, which serves a completely different purpose and does not equate to supported decision-making. Additionally, because case managers often do not engage the family until a facility is already preparing for discharge, my child was improperly discharged more than once. A physician even arbitrarily declared my child having capacity without conducting a formal clinical assessment, which was not discovered until there was an inquiry about the medical record. Families and surrogates without a background in regulatory science should not have to navigate operational chaos just to secure appropriate care for their loved one. The clinical data supports a clear engagement dividend. When family members are actively engaged, medication compliance improves by 60 to 80%, effectively breaking down the cycle of readmission. On the other hand, excluding families is incredibly expensive. A single cycle of readmission costs over $35,000, and $17,500 of that is entirely preventable through family advocacy. We are simply asking the state to stop cutting the safety net that families have legally and proactively put in place. Please support Senate Bill 549 to ensure that healing, equity, and representation is the continuity of care within our mental health community. Thank you.
It'll slide over. It's got lots of cord. Thank you.
Good evening. Good afternoon. My name is Dolores Millhouse, and I'm here in support of Senate Bill 549. Thank you for allowing us to be here, Chair Bidel, as well as Vice Chair Hayes and members of the Finance Committee. This issue was first brought forward as a District 25 constituent, Ms. Smith, and a mother who recognized how difficult it can be for families to support their loved ones on navigating mental health treatment. Sometimes legislation requires more than policy analysis. It requires empathy and an understanding of what families experience when mental health crises enter their homes. As a certified adult and youth mental health first aider, I teach community members how to recognize the signs of mental health crises, listen without judgment, and connect individuals to appropriate professional care. Families are often doing exactly that long before a clinical professional becomes involved. Yet too often, when treatment begins, those same families find themselves shut out of the conversation that determine how their loved ones will be treated. Senate Bill 549, the Her Continuity of Care Act, corrects that imbalance by ensuring mental health patients are informed in plain language of their right to include trusted family members or other authorized individuals in treatment planning when they choose to do so. Together with Senate Bill 550, this legislative reflects a growing recognition that families are not barriers to care, but essential partners when it's necessary. That bill, restores something families need the most: hope that recovery is possible, and hope that the system will work with the families rather than around them. As Maryland Mother of the Year, I believe our systems must recognize the critical role families play in supporting recovery. Mental health recovery is stronger when families are partners in care. I respectfully request a favorable report on Senate Bill 549. Thank you for your time and consideration.
Thank you. Do I have any questions for this panel? I don't see any questions. Thank you all for your testimony. We have someone from the Maryland Office of Public Defender, Sanjeev Varghese. No. Is anyone here from the Office of the Public Defender? Okay. We have Lucine Parsley, Disability Rights Maryland. Is she here? No. And then virtually we have Michelle Kuando. And she's not here either. Okay. All right, well then that ends the hearing on Senate Bill 549. Senator Lamb, would you like to do Senate Bill 790, the Public Health Reform Act? It's joint with B&T, but they're not going to be here today, so you can start with Tony Guyden, Anne Arundel County Department of Health, and Dr. Manaski Brewster, St. Mary's Health Officer.
Oh, it's okay.
I've never seen names like that.
Here, I'll move over.
Okay. More people there than are signed up. Senator, you want to?
Yeah, I think the department is here favorable with amendment, so
Okay.
if they want to come up, here we can all just
Okay.
take us all up.
All right, everybody, please identify yourself, because I don't have everybody on the list. Thank you.
All right, I'll go ahead and kick this off and start. So thank you, Chair Beidel, members of the Senate Finance Committee, here to present the Public Health Reform Act of 2026, SB 790, for the record, Clarence Lamb, Senator District 12. For those of you who were in the legislature, well, I guess all of us were here then, this is the same term, but you may recall that we passed legislation back in 2023 to create a commission on public health, which was tasked with assessing the state's public health system and also on making recommendations on how to improve it. And that passed out of this committee under our prior chair. And the tasks, the commission has been hard at work over the last couple years. After countless hours of meetings, the commission issued a very substantial report earlier this year, which includes many legislative, funding, and departmental recommendations. And while it may take many years to fully implement the recommendations of the report, this attempts a first start in being able to get the ball moving on some of the recommendations that came out of the Public Health Commission's report. Initially, this was the Senate's designee was Senator Ariana Kelly to the commission, and then I became the Senate designee for the last year and a half. Chair Bagnall was the House's designee to the Commission on Public Health, and she's also invested a lot of time into this and is the House sponsor of the cross-file of this bill. Which had its hearing last week. Most of the language of the bills is extending the Commission on Public Health and making it a little bit narrower and tasking it with some more discrete tasks of monitoring and updating the General Assembly on implementation of the recommendations of the report. Implementing the Commission recommendations will take coordinated efforts from multiple departments and across several levels of government. So we believe, and with the Commission's support, believe this will be helpful to continue to bring the different stakeholders together to continue addressing the barriers that we're seeing, knocking those down when it comes to implementation, and then providing a report back to the General Assembly on continued progress. The commission had 3 co-chairs. That was a creation of this committee. One of the chairs is here, Dr. Mina Brewster from St. Mary's County as the health officer, and can also speak to the work of the commission as well. In this current iteration with this bill, the chair of the commission will provide staff, so there won't be any incurred costs to the state, similar to the arrangements that we have had for the commission the prior couple years. The rest of this bill seeks to implement some of the low-hanging fruit recommendations that came out of the commission's report, which were pretty extensive. Would encourage members, probably after session, to be able to familiarize yourself with the report of the commission. They've invested a lot of time into that. These initial recommendations that were put into effect include providing more clarity that the state's Medical Reserve Corps is open to non-clinician volunteers that could support the state during a public health emergency. Additionally, the bill requires the Department of Health to work with the counties to jointly procure an electronic medical record system when possible to be used across various local health departments. The department does have some concerns about the language in the bill to streamline local health department hiring and contracting. One of the issues that has consistently come up throughout the commission process was the length of time that it takes the department to approve local hiring in local health departments, even when only county funds are being used to hire those positions. This has resulted in local health departments missing out on using some grant funding to hire their own staff that counties need to support their local public health efforts. Additionally, delays in approving contracts have made it very difficult for local health departments to get reimbursed by insurance companies, just as an example, which means that counties are essentially providing services for free. I recognize the department has some concerns about these 2 provisions within the bill. Happy to make and consider amendments, but ultimately the delays that our local health departments are experiencing are one of the biggest issues limiting their ability to do their work and to really advance public health in their local jurisdictions. Our county health departments need real action on these issues. The final part of the bill creates a public health workforce development fund. Just like our more traditional healthcare workforce, our public health systems are in need of additional staffing as well. The training is certainly very different. The experiences are very different. Additionally, low pay in the public health system means that it is even harder to attract recent graduates with student loans to pay off. The department's concern is that the potential of using these funds from the Population Health Improvement Fund to support the Workforce Fund is concerning, and the department contends that the Population Health Improvement Fund can only be used to support the AHEAD population health goals. We believe that at a very high level, this may be accurate, but I'm not sure how we're going to even get close to meeting our public health metrics without an improved public health workforce. That a public health workforce is integral to meeting all of those outcomes that we are hoping to target as part of the AHEAD agreement. Our current AHEAD targets include behavioral health follow-up care, increased colon cancer screenings, and reductions in the number of people with uncontrolled diabetes. Addressing these issues will require a multi-pronged approach, but we will never do so without a larger workforce, which is why we are looking to be able to at least set up this fund and to deal with the funding of it later. Finally, the bill says that the funds from the Population Health Fund may be used to support the workforce. That's a may, not a shall, which I would contend gives the department some flexibility here to work with the Center for Medicare and Medicaid Services to ensure that the workforce investments are consistent with the AHEAD agreement. The bill folder also includes amendment ideas from MACO and also the Department of Emergency Management, which have been requested. So the Commission on Public Health took a lot of volunteer time from many stakeholders, and I want to commend them on their efforts. They had a very public process with a lot of public input. They tried to reach out to all areas within the state to be able to solicit that input, made visits to many different public health institutions, facilities, and health departments. And so publicly I want to thank the Commission. I know we don't have all of the commissioners here, but they put in a tremendous amount of time into this, and I think we owe it to them to ensure that we continue to push this effort forward. Additionally, our county health departments work very hard to support our communities, and we should help put them in the best possible position, and happy to continue working with the state health department as well on these efforts. So with that, that is the bill. Let me turn it over to Dr. Brewster first. Is that okay? And then take questions at the end.
Great, thank you. Good afternoon, Chair Beidel and members of the committee. Thank you for the opportunity to provide informational testimony on Senate Bill 790. My name is Mina Brewster. I serve as a St. Mary's County Health Officer and co-chair of the Maryland Commission on Public Health. I submitted a letter of information to the committee, and I'm here today to provide brief context on the Commission's work as it relates to this bill. Over the past 2 years, as Senator Lamb described, the Commission conducted a comprehensive assessment of Maryland's public health system and issued recommendations aimed at modernizing how our public health infrastructure functions. Broadly, these recommendations focus on 5 key themes: strengthening public health infrastructure, including optimizing the shared state-local governance of public health, supporting sustainable and flexible financing structures, and improving the efficiency of our HR processes. 2, modernizing communication, data, and information technology tools. 3rd, strengthening the current and future public health workforce. 4th, leveraging and formalizing partnerships across sectors. And 5th, improving alignment between public health and the healthcare delivery system. So while this bill does not encompass the full scope of the Commission's recommendations, several of its provisions do align with these broader themes. In particular, the provisions related to workforce development, hiring flexibility, coordination with healthcare institutions, sustainable financing mechanisms for local health departments, and strengthening surge capacity reflect the types of structural improvements the Commission identified as important for ensuring Maryland's public health system can operate efficiently and respond effectively to local community needs. My submitted letter of information provides additional detail on how specific provisions of the bill align with the individual Commission recommendations. Thank you.
Good afternoon. My name is Tony Gedden, and I am the Anne Arundel County Health Officer, and I also currently serve as the president of the Maryland Association of County Health Officers. And this afternoon, we would like to submit our position on behalf of the Maryland Association of County Health Officers in support of this bill. As Dr. Brewster mentioned and Senator Lamb, we've had a tremendous amount of support from local health officers and health departments and various levels of staff really participating on this commission and invested in this work and understanding how shared governance is working and what can be improved in the state of Maryland as we're working through ways to improve governmental public health specifically. And I think the things that we're looking at in this bill, electronic health records, I can't understate or overstate how important those are to the work that we're doing throughout various forms of clinical care and our ability to really access the best and things that will really help our patients and the communities is crucial. And we find that that work is better done in partnership with our state health department. And we want to be partners in that work and making sure that we are getting the best systems that are interoperable, that analyze data, and that allow us to share with you all what we're seeing as we're treating people. Also strengthening our workforce. We know that working in governmental public health is not always the best paying role, but we want to make sure that we're finding ways to increase that, finding ways to recruit talented and passionate individuals who want to do this work. And we're doing that now, and we could use some help in how we can improve that in the future. In addition, we want to make sure that we continue the wonderful collaborations that some of us have with our hospital partners. I personally have a wonderful relationship with the hospitals in Anne Arundel County, and if there were opportunities to further collaborate, we'd want to make sure that those opportunities are available to health officers and that we are not held back from sitting on boards or being a part of those meetings as a chief health strategist for our counties. So we support this bill and we appreciate your time today.
Thank you. Are you going to testify?
So good afternoon, Chair Beidel and members of the committee. For the record, my name is Dr. Meg Sullivan, and I currently serve as the Deputy Secretary for Public Health Services at the Maryland Department of Health. And thank you for the opportunity to speak today to express the department's support in proposed amendments for the Public Health Reform Act. Senate Bill 790 represents an opportunity for the department and other state agencies to take vital steps to further strengthen public health infrastructure in Maryland. The department supports this bill as we recognize and concur that improvements can and should be made to enhance coordination and communication across the full spectrum of governmental public health. The department shares the goals of the Commission on Public Health to enhance the foundational capabilities across the department and to improve health for all Marylanders, and have collaborated over the last year with the Commission on assessments, work group meetings, and regular check-ins. We support the proposed extension of the Commission as a framework to continue this collaboration. Our leadership team has worked to enhance support for and collaboration with local health departments in line with the goals of the Commission on Public Health recommendations, and we welcome the opportunity to continue to build upon this progress in partnership with the committee and local health officers. In line with this support, we are offering a few amendments to ensure that these processes are consistent with other state statutes and federal policies, including alignment with the state personnel system, the State Ethics Commission, and the department's agreements with the Center for Medicare and Medicaid in implementing Maryland's AHEAD model. Overall, though, the department appreciates the opportunity to provide this information and looks forward to continued collaboration with the Commission to build a more resilient public health system, and we respectfully request a favorable report on this bill with our suggested amendments. Thank you.
Ms. Sullivan, are your amendments the ones that were submitted by Megan Lynch in the Health Department? Okay. Correct. Because I just had you as oral, so that's great. Okay, thank you.
Yes.
Okay, so I think that's all the people for this panel. Do I have any questions? We'll certainly review those amendments. Thank you. That ends the hearing on Senate Bill 790. Now, Senator Lamb, you have Senate Bill 792, Hospitals Immigration Enforcement. You have Nufa Amador, Hernandez, Jane Cranky, and Bridge Dumais. And two are favorable with amendments, but you have them on your panel.
Yes, he's submitted it. Right. All right. Thank you, Madam Chair, members of the Senate Finance Committee, and here to present SB 792 on hospitals and immigration enforcement action and a policy requirement. So for the record, Clarence Lamb, Senator in District 12. I think this committee is obviously familiar with the backdrop of what we're seeing across the country when it comes to some of the challenges our immigrant community are facing. This year, we have witnessed unprecedented changes in immigration enforcement by the federal government. While we have seen the images of Minnesota and elsewhere of masked ICE agents engaging in aggressive raids in immigrant-heavy communities, this has frequently resulted in violence and other support that's needed where hospital care has become essential. While it's been the longstanding policy of multiple administrations not to engage in immigration operations at sensitive locations such as churches, schools, or hospitals, that guidance from the federal government has since been rescinded. We have seen across the country, including here in Maryland, federal immigration officials at our hospitals causing a disruption to essential life-saving work. In Minnesota, for example, at Hennepin Medical Center in Minneapolis, ICE agents were documented patrolling the hospital and demanding that staff and patients show proof of citizenship. This had a chilling effect on patients, with immigrants afraid that they would be stopped and potentially detained. No-show rates have increased. Women in labor are having unwanted home births because they're afraid to bring their other children to the hospital. And we've heard from many instances where providers in some of these healthcare facilities who are concerned about their own well-being and safety as well as those of their patients. Many of them have been asked if there were immigration enforcement agents that came to an emergency department, for example, what the process and protocol is. There seems to be some confusion oftentimes if there isn't proper training or clarity in that policy that providers may be on the front lines of trying to redirect individuals. And that's why this policy is so important to be able to implement a standardized policy across our hospitals, private hospitals, so that these types of instances can be properly addressed by staff that are in our hospitals. While all patients are entitled to a private conversation with their doctor and federal immigration officials cannot enter non-public areas of the hospital without a judicial warrant, it is up to our frontline healthcare workers to adjudicate this. Doctors and nurses are placed in a difficult position of both caring for their patients, protecting their patients' rights, and also following some very rapidly changing laws and federal guidance. This bill ensures that patients, visitors, doctors, nurses, and staff, all of whom use our healthcare facilities, know that hospitals have a clear protocol to protect the safety and rights of those who come through their doors. We have worked with multiple stakeholders and have amended the bill to better serve the needs of residents in our state. The current amended bill requires only 3 items. So the top front of the bill, and I think there's a reprint that's probably in the bill folder online, the top portion of the bill has been amended out. And so the only 3 provisions that remain are the following: that hospitals have to have a policy for how to interact with federal officials, that this policy is readily available to employees for reference, and lastly, which I think is very important, that employees are educated on this policy. And that's it. We are not prohibiting lawful immigration enforcement or mandating that hospitals perform any new duty. We think it is important that providers that are and employees and staff that are working in hospitals are educated and informed on this, because we have heard from many providers where they're not sure who to turn to if they see a federal official or agent coming through their door. They may say, go contact my medical director, or they'll contact the charge nurse. You know, there's just a lack of familiarity there. All healthcare providers have to go through some annual training, things on bloodborne pathogens and emergency response. This policy then, whatever the policy of that institution is, would be included as part of that standardized annual education that must be completed by that provider. Last year, we passed legislation to require that the Attorney General issue guidance to hospitals and for public hospitals to adopt internal policies, that is public hospitals. But there is no requirement for private hospitals to have a policy or for any hospital to train their staff on what that policy is. Nothing in this bill will require hospitals to interfere with immigration officials or to undermine federal law. I would like to thank the other stakeholders who work with us closely on this bill, the Maryland Hospital Association, SEIU 1199, also CASA, and glad to have them here as part of the sponsor panel. So with that, let me turn it over to other members of the panel and then happy to take questions at the end.
Hi, Chair. Good afternoon, Chair Vital, members of the Finance Committee. My name is Jane Krinke. I'm here on behalf of the Maryland Hospital Association in support of Senate Bill 792 with the sponsors' amendments. As you've heard, we strive to ensure our facilities are safe places of healing for everyone, regardless of citizenship status. And over the years, we've been working with the Attorney General's office to ensure that we have policies in place to support this. Since back in 2017, we've been working on ensuring we have policies that meet the AG's requirements. In January 2025, the Attorney General released additional guidance, noting, like Senator Lamb said, the reversal at the federal level of their policies, and we have adopted our policies to make this evident. And so the AG's guidance includes recommendations on staff training, how to interact with immigration officials, and so we believe that we are able to comply with this legislation without any problems. So with that, we'd ask for a favorable report.
Good afternoon, Madam Chair and members of the committee. My name is Ninfa Amador Hernandez, and I'm CASA's policy manager. We Are CASA is the nation's largest immigrants' rights and advocacy organization, and we are also a powerhouse, national powerhouse organization building power and improving the quality of life in working class Black, Latina, Afro-descendant, Indigenous, and immigrant communities. In the past year, DHS, or the Department of Homeland Security, has sought to meet an arbitrary quota of detaining 3,000 immigrants per day. We Are CASA, and I'm sure many of you, either through your phone screens, have witnessed how families are being taken from our communities to meet this quota. And that has impacted CASA memberships and immigrants across the state. And we have witnessed families retrieving from community engagement, including doing essential activities and basic needs like going to school or even seeking medical attention. SB 792 is a critical step towards ensuring this unhindered access to our medical facilities in the state, particularly private hospitals, by ensuring that staff at these hospitals have proper guidelines and know what to do if and when they are to face ICE enforcement. For over a decade, as was noted, DHS had a policy of not coming to sensitive locations like hospitals. However, this past January, that has been revoked, leaving many immigrant families vulnerable to enforcement in these locations and leaving many state staff at these locations without the proper policies and tools in place to know what to do. With your support, in 2025, the Maryland General Assembly passed the Maryland Values Act in response to the rescission of that federal memo. Maryland reiterated its commitment to immigrant families seeking access to these basic benefits. However, private hospitals are missing from that list. We appreciate the stakeholders, MHA, SEIU, for supporting this bill as well, and we urge your favorable report.
Thank you. Do I have any questions for this panel? Oh, I'm sorry, Bridget.
Good afternoon, Madam Chair, members of the committee. My name is Bridge Dumais. I'm the political coordinator with 1199 SEIU United Healthcare Workers East. 1199 is the largest healthcare workers union in the nation. Here in Maryland, we have over 10,000 members who work in our hospitals, long-term care facilities, and federally qualified health centers. And healthcare workforce is disproportionately immigrant populations. Creating a policy regarding immigration enforcement action at hospitals is vital to the safety of healthcare workers, patients, and their family members. We support SB 792 as amended, and we would love to work with the bill sponsor on a further friendly amendment. This legislation is a critical step towards protecting the safety and privacy of patients and workers while curbing the federal government's attacks on patients, neighbors, and loved ones. The current political climate is already causing many Marylanders to fear accessing necessary health care, leading to some delay in care and increasing the risk of more serious health complications. It will also be important to consider policies to support immigrant healthcare workers, such as immigration-related leave of absences from work, work authorization support, and workplace safety guidelines. Our requested amendment would be to include stakeholders who represent healthcare workers themselves in the policy development process to ensure that workers are consulted in the creation and implementation of this policy. Hospital administrations in Maryland have had a long history of implementing policies without consulting workers and seeing those policies fail in practice because executives are disconnected from the realities of the day-to-day work frontline workers are responsible for. Workers having a seat at the table will increase protections and ease implementation, which ultimately benefits Maryland patients and communities the most. We urge a favorable report and hope to work with the sponsor on this amendment. Thank you.
And with the amendment, and their sponsor amendments there, that should eliminate the fiscal note on this bill as well.
Good. No other questions? Thank you very much. I think that ends this hearing on Senate Bill 792. Senator Lamb, you have the last bill of the day. Senate Bill 798, Public Health Maryland Medical Assistance Program Tobacco Cessation. And you have a big panel. Janeka Deepak, Julia Melman, Michael Patty, Devon Nixon, and then we have 3 virtuals.
We have the online. Dr. Khanna go first.
Yeah.
After you. Yeah.
All right. All right, I'll go ahead and kick it off. We have members of the panel here, and I think one of our members of the sponsor panel is also virtual. So, good afternoon, Chair Beidel, members of the Senate Finance Committee, here to introduce Senate Bill 798 on tobacco cessation products for the Maryland Medical Assistance Program. For the record, Clarence Lamb, Senator in District 12. Tobacco use remains a leading cause of preventable death in Maryland and also across the country. It contributes directly to heart disease, stroke, cancer, chronic lung disease, and diabetes-related complications, all conditions that drive avoidable hospitalizations, emergency department visits, and also long-term healthcare costs. Despite decades of progress, tobacco dependence continues to disproportionately affect lower-income communities that already face barriers to care. This bill ensures Medicaid coverage for all FDA-approved tobacco cessation medications and for evidence-based cessation services recommended by the U.S. Preventive Services Task Force, including counseling and other clinically proven supports. It removes unnecessary barriers that we know interfere with quitting smoking. For example, the need for prior authorization, cost sharing, and mandatory counseling as a condition for medication coverage. From a clinical and public health perspective, all of this matters. Given that tobacco dependence is a chronic condition, many people require multiple attempts at quitting before they are successful. And research consistently shows that access to both medication and behavioral support significantly improves quit rates. When coverage is restricted or complicated, people delay or abandon treatment, and the consequences show up later as preventable disease. This is a proven approach that we're taking. Other states have already demonstrated that comprehensive Medicaid tobacco cessation coverage works. For example, Ohio has implemented a similar policy requiring coverage of FDA-approved medications. And the U.S. Preventive Services Task Force recommended cessation services while prohibiting utilization barriers. They've recognized that cessation is a core preventive health investment rather than an optional benefit. This bill is also about health equity. Communities that have been historically targeted by tobacco marketing and that face higher rates of chronic disease are oftentimes the same communities most likely to rely on Medicaid for care. Expanding access to cessation services is one of the most effective and immediate ways that we can reduce disparities while improving population health outcomes. Lastly, I recognize that the fiscal note on this bill does cost about $1 million, but I believe that is ignoring some of the significant cost savings to Medicaid, our state program, by helping people stop smoking. A smoker is over two times as expensive
to care for as a former smoker, and nationwide, about 15% of all Medicaid costs are caused by smoking. Certainly open to ideas on how to narrow the scope of this bill, but I do believe that this bill will ultimately save money in the long run, and oftentimes that is not accounted for in the fiscal note that you are seeing. So for these reasons, respectfully ask for a favorable report on SB 798. And let me turn over to members of the panel to take questions at the end. If we can start with Dr. Khanna on the virtual panel first, and then we'll come back to in-person.
Thank you, Dr. Lamb, and members of the community. Thank you for allowing me to give you a little story about my own individual experience. I'm Niharika Khanna. I'm a family physician, and I practice in Maryland. I do see a lot of cancer patients, and we were seeing this gentleman who had a history of cancer who was very interested in trying to quit using tobacco. And we had him try all of the 7 FDA-approved medications, some of which are nicotine replacement therapies, to which he gave all of them a very good shot. You know, he really tried. And eventually he was placed on varenicline, which is Chantix, on which he finally was able to stop smoking. And as Dr. Lamb mentioned, it takes sometimes many tries, and it took him many tries to get there, but he finally did get there. And 6 months later, with a review by the insurance, this is a Medicaid insurance, they said, no, he needs prior authorization, which we then had to go through all of the paperwork to get him the prior authorization, and they turned him down. So, well, now our choice was, what do? Either he pays for it out of pocket or we borrow from somewhere. So eventually we settled on GoodRx, which then gave him a cost of $156 a month, which is a lot for a poor gentleman on a fixed income who is really trying to take care of his health. So I thought it was very, very unfortunate. But what happened after that was that he couldn't always get his medication, so he was dealing with a lot of stress now. And because of that stress, he fell back into using tobacco. Now, this is already a person who's had a prior cancer. He already has lungs that are diseased. He eventually, during our follow-up, within 2 years, he then developed a second cancer. So I can't tell you the importance of trying to get people off tobacco, and we really appreciate your review of this particular Senate bill. Thank you.
Okay, thank you, Chair Bidal and members of this committee. I'm Janaki Deepak. I'm a pulmonary and critical care physician. I'm here on behalf of the American College of Physicians, Maryland chapter. We are the largest internal medicine organization in the United States. I'm here in talking favorably about Senate Bill 798. I would like to thank Senator Lamb and also Delegate Hill in the House for House Bill 1264 addressing this big problem. Senate Bill 798 is asking for simple changes to the Medicaid coverage. We are saying that tobacco treatment should be without barriers in the Medicaid population who already have so many barriers. So stop prior authorizations, stop step therapy, and do not limit quit attempts for tobacco treatment. I would like to bring to you Mary Doe, Jane Doe, our patient who was 40 years old, came to me smoking 4 packs of cigarettes, had tried multiple attempts at getting many medications. She was denied every single time. She was on Medicaid, and we ended up having to supply her the patches and the gum, and she would do things like cut the patches in half, sometimes in quarters, to make it extend, and she lived visit to visit to get samples from us because it was just not covered for her. And she had multiple attempts at stopping smoking. This went on for 3 years. And ultimately, the stressors of smoking and her multiple comorbid conditions ended up with her actually relapsing and getting into big problems and hospitalizations, and we have lost her. I ask you one thing. If patients are using heroin and opiate use disorders, we offer them methadone. Why are we telling our patients to quit tobacco? We need to make sure that we give them treatment for tobacco and not create barriers. Thank you so much. Hope for a favorable outcome.
Excuse me. Good afternoon, Madam Chair and members of the Finance Committee. My name is Julia Mohamed. I'm a nurse and a tobacco treatment specialist. I'm testifying within my individual capacity and expertise in favor of Senate Bill 798. After we see patients in clinic, my role is to follow up with the patients by phone and collaborate with their pharmacy to make sure that they get their medications. In our Medicaid patients, they often do not get the medications largely due to prior authorizations and step therapy. Last week, we saw a patient with Medicaid who just can't get the patches and the lozenges at all. Yesterday, I talked to a patient whose nicotine nasal spray requires a prior authorization. She's on Medicaid. Last week, we had the same situation with a different patient. So we're facing a lot of barriers. This also increases our workload, and it delays the patient's care. Lately, it has been a little bit easier to get varenicline, previously Chantix covered, but when it was the brand name Chantix, we had a lot of trouble. One patient in particular struggled for many years. He eventually did get varenicline covered by his insurance, but he had to pay a copay, which he could not afford. So instead, his pharmacy covered that for him. But compare that to a patient who we saw at this exact same time with excellent commercial insurance. She got the medication right away, Chantix, and she stopped smoking within a month of starting the medication. So the disparities here are really striking. That patient had wonderful success. The first patient struggled for many years. Of our patients on Medicaid, a lot of them were not able to get the nicotine inhaler, which is now discontinued by the manufacturer. We had one patient who ran out of inhalers just after she stopped smoking, and she says that's the only thing that helped her stop smoking, so her timing was perfect. Our patients with Medicaid are in a really difficult position because they're more likely to smoke than the general population, and they face many more barriers to treatment, especially the step therapy and prior authorizations. I respectfully request a favorable report. Thank you.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Davon Nixon. I'm a student attorney with the Public Health Law Clinic at the University of Maryland Cary Law. I'm here today to support SB 798. Under current federal law, Medicaid must cover tobacco cessation medications, and it must cover counseling and medications for pregnant beneficiaries. For non-pregnant adults enrolled through Medicaid expansion, cessation interventions are considered preventative services. However, federal law still allows states to impose administrative barriers to accessing treatment, such as prior authorization, and limits on counseling sessions and treatment duration. Maryland meets that federal baseline. Medications are covered, but prior authorization may still apply, and counseling is not expressly required in statute. As a result, access can vary by plan, and treatment can be delayed. CDC reporting shows that 20 states provide comprehensive coverage of cessation medications in both individual and group counseling and their traditional Medicaid programs. Some states, such as Ohio, have codified that coverage into statute and restrict prior authorization and other barriers. Access to both individual and group counseling is essential because these evidence-based interventions improve cessation success. And removing prior authorization is equally critical because research shows that coverage barriers reduce the use of cessation treatment at the very moment someone is ready to quit. SB 798 would move Maryland in that direction. It requires Medicaid across the board to add individual and group counseling and removes prior authorization as a barrier. This is a modest but meaningful step that moves Maryland toward a more comprehensive, lower barrier cessation coverage model. For those reasons, we ask for a favorable report. Thank you.
Michael Patty here this afternoon on behalf of the American Cancer Society Cancer Action Network in support of Senate Bill 798. I just want to highlight really two things. The first one is MCOs and prior authorization. MCOs have a lot of inconsistency between MCOs on what drugs they attach prior authorization to. And then obviously the response to providers to get that prior authorization approved. So, removing prior authorization is certainly a step in the right way to making sure that patients can get the medications they need. The second thing I want to highlight is what Senator Lamb focused on was the fiscal note. Not often do we see the Department of Legislative Services speculate, but in the very last sentence of the fiscal note, they do highlight that while there might be increased utilization of these services and medications, it's likely to lead to a reduction in the dependence of tobacco and result in associated long-term savings. There's some written testimony that a number of organizations supported with a footnote to kind of highlight what those savings could be. These aren't from the Department of Legislative Services, but I just want to make sure that you were all aware. In the fiscal note, MDH highlighted 1.5 million in costs. But what we've seen with a 1% reduction in Medicaid smoking, the results I think are astronomical. It could be upwards of $53 million a year, with a split between obviously federal and state monies, and then obviously a much larger savings over a number of years. Just to give you an idea, I think in MDH's written testimony, they highlighted that there could be a cost to the state over 5 years of around $7 million. If you extrapolate the numbers that I just said, it would be over 5 years or roughly a $268 million savings to the state to get people onto these products to help break that tobacco addiction. So with that, we'd ask for a favorable report. Thank you.
Thank you. And we have two virtuals. Anne?
Great. Thank you. Can you hear me okay?
I can hear you. Thank
Great.
you.
Madam Chair and members of the committee, thank you for the opportunity to provide testimony. My name's Anne DiGiulio, and I'm the Senior Director of Nationwide Tobacco Cessation and Health Policy at the American Lung Association. We are here in strong support of Senate Bill 798 and thank Senator Lamb for bringing it forward. You have written comments from our organization and partners, so I will be brief. I will echo many of the experts you've heard before about the importance of access to a comprehensive barrier-free quit smoking benefit that includes all FDA-approved medications and all 3 forms of counseling to help people quit. In 2020, the Surgeon General concluded that this barrier-free benefit leads to higher rates of quitting and is cost-effective. Tobacco use remains the leading cause of preventable death in the United States, killing approximately 490,000 Americans every year, which includes 7,490 Marylanders each year. And people that smoke want to quit. Approximately 7 out of 10 people, when surveyed, say that they want to quit, but only 1 in 10 people who smoke quit successfully each year. And this is true across demographics, both for the general population as well as low-income individuals and Medicaid enrollees. And just speaking of Medicaid enrollees, approximately 25% of Marylanders who are enrolled in Medicaid smoke. This is compared to about 14% of Marylanders overall. So we see this disparity, which has been highlighted before, of more smoking in the Medicaid population. According to the Lung Association State of Tobacco Control Report, Maryland's healthcare cost attributed to smoking is $2.7 billion each year. And data show, which my colleague from ACS can flag as well, that if the Maryland smoking rate decreased by, again, just 1%, the state would save over $53 million in Medicaid costs in the following year alone. Maryland receives a B grade in access to cessation services in our State of Tobacco Control Report with some Medicaid enrollees. And so I just want to say the Lung Association asks for a favorable report from this committee. Thank you for the opportunity to testify.
Thank you. And finally, it's Panegis. Yes. Panegis, you want to give us your testimony?
Of course. Thank you, Madam Chair, members of the committee. My name is Dr. Panegis Galiatsatos. I wear many hats. I'm a practicing pulmonologist at Johns Hopkins. I'm the director of our tobacco treatment and cancer screening clinic from Johns Hopkins that practices in Baltimore City, Howard County, and in Montgomery County. I also am the vice chair for the Office of Population Health for the Johns Hopkins Health System. And today I'm here as a volunteer medical spokesperson for the American Lung Association. I'm here in strong support of the Senate Bill 798, and thank you, Senator Lamb, for bringing it forward. As a physician, as a son of Baltimore and a son of Maryland, practicing in the tobacco treatment clinic has been one of the most rewarding things I have ever done. Right? My father was a union painter. My mother was a union seamstress. I grew up in these union halls. All of those individuals that helped build the foundation of Baltimore smoked, and many of them have become my patients generations later. That, for me, is one of the strongest reasons we need to advocate for this bill. We need to provide these men and women that built the city using their hands the right services that every other patient gets for chronic disease management. Just because they are smokers, we should not make it more difficult for them because they have such great ease to access the tobacco. They need the similar ease to access these medications. All of the 10 treatments are considered first-line treatments and are evidence-based. Our patients deserve the sophistication and ease of access that this bill provides. Last thing I will say is that practicing tobacco dependence management for my patients, when I see them finally motivated, we made progress. The switch has flipped. They're eager and excited to engage, eager and excited to walk the journey becoming tobacco independent and a non-smoker. Anything that gets in their way sometimes sabotages the plan. So the Lung Association supports Senate Bill 798, and for this we ask for favorable support from the committee.
Thank you. Do I have any questions for this panel or the virtual? Seeing no questions, that ends the hearing for Senate Bill 798, and it ends our hearings for the day. Thank you.